Mr. Snyder's representative. Go ahead.
Yes.
Good morning, Mr. Chairman, members of the board. My name is Norm Semanko. I'm an attorney with Parsons, Bailey, and Latimer in Boise. I'm in my 29th year practicing law and appeared in a good number of counties. I was in Bonner County yesterday in front of the commissioners on a matter, and glad to be here in Boise County today. My role today is as the local counsel for Mr. Snyder and what have been characterized as neighbors. In Idaho, to practice law, you have to be licensed in the state of Idaho, and that includes representing folks at proceedings like this. We also have a rule in Idaho under our rules of professional conduct that allows attorneys that are not licensed in Idaho, but bring certain level of expertise to appear before tribunals like yours and provide testimony, otherwise represent folks. Mr. Campanelli, who's on the screen with the Zoom, and we very much appreciate the county making this available for us, is that attorney. In Idaho, for someone to appear, if there's a procedure that a court or other tribunal has for applying to appear, what's called pro hoc vici, then you have to do that. You don't really have a set procedure for doing that, so we're following the rules the best we can, and that includes that the primary attorney, which of course is Mr. Campanelli, be accompanied by local counsel, and that the local counsel appear at the proceeding. So I'm here and I'm glad to be here, but I'm not planning to say much unless it's necessary, and I'm going to turn it over to Mr. Campanelli. Thank you for your time.
Thank you.
Thank you, members of the board. I appreciate the opportunity to speak before you. My name is Mr. Campanelli. I am an attorney. I'm admitted to federal courts across the United States, but not the state of Idaho. My area of practice focuses much on the Federal Telecommunications Act of 1996 and the obligations it imposes upon local governments when entertaining applications for the installation of wireless facilities. And so it certainly applies here. As you may or may not know, when the Telecommunications Act was adopted back in 1996, Congress preserved to local governments what is called the general authority to regulate the placement of wireless facilities. Employing that power since 1996, local governments have adopted smart planning provisions, which are designed to regulate cell towers, especially ones such as this, to avoid adverse impacts against property owners, to minimize the number of towers needed to provide wireless service in a given jurisdiction, and to make sure that a proposed installation is both necessary and reasonable. The county of Boise has such a provision, and it also has codified its legislative intent for that provision. I respectfully submit on behalf of Mr. Snyder and the 34 other property owners I represent that this appeal should be granted and that the decision to approve the CUP should be overturned, because granting the CUP to Horizon to build a 15-story tower so close to residential homes would not only violate the terms of the Unified Land Use Ordinance, it would actually inflict upon the homeowners the precise types of adverse impacts you drafted a conditional use permit requirement to prevent. Now, the two most common types of adverse impacts caused by the irresponsible placement of a wireless facility are adverse aesthetic impacts and reduction in property values. In a memorandum that we've submitted to you, we submitted to you the arguments and the case law that supports that argument. These are perfectly valid legal grounds for denying an application of the conditional use permit, both under the Unified Land Use Ordinance and federal law. Federal law, however, also provides that if you were to deny this application, any denial has to be based upon substantial evidence. And so in addition to the arguments, I have submitted to you substantial evidence as has been recognized by federal courts. Now, how do you provide evidence of the adverse impacts that this 15-story tower is going to inflict upon the nearby homes? Federal judges have ruled that the persons in the best position to both know and understand both the nature and the extent of adverse aesthetic impacts are nearby homeowners themselves. And so because of that, we have provided personalized letters from the perspective of each of the homeowners that are going to sustain these adverse impacts of the actual adverse aesthetic impacts they will sustain. According to federal courts, these are substantial evidence of adverse aesthetic impacts. I implore each of the board members, they're next as Exhibit A to our memorandum, please read them, please look at them and get a sense of the actual adverse aesthetic impacts you'll see. Not surprisingly, the applicant has not provided any visual impact analysis, which includes any photo simulations taken from the perspective of the closest homes. This is something that's done on a regular basis, and federal courts have said these things should be submitted, but they're not. So be it. The other most common adverse impact inflicted by a tower of this magnitude is it typically reduces the value of the nearby properties if a tower is irresponsibly placed. Once again, I'm not just submitting an argument that will reduce property values. That argument is supported by substantial evidence. That substantial evidence is in the form of local real estate brokers' professional opinion letters, in which they submit their professional opinion that this proposed installation at this proposed site will reduce the value of the nearby homes anywhere from 10 to 25%. Now, I've seen opposition put in by the applicant's attorney, who I believe is trying to represent that professional opinion letters from brokers are not sufficient. According to federal courts, brokers' letters, professional opinions are substantial evidence of the actual adverse impact this proposed installation would have on the nearby property values. You don't need real estate appraisals. You can take professional opinion letters from brokers, especially whereas here, the brokers have an acute familiarity with the specific real estate market for which they're providing a professional opinion. These brokers, in their professional opinion as licensed professionals, indicate in their letters annexed as Exhibit B to the memorandum that will reduce the value of the nearby homes by anywhere from 10 to 25%. Of equal import is the fact that granting this application would be inconsistent with smart planning, and the fact that this applicant has failed to provide the county with any probative evidence showing that granting this application for a CUP would be consistent with smart planning. One of the things local governments have been doing across the entire United States is to try to minimize the number of towers you need to provide personal wireless services. And to do that, anytime an applicant submits an application, they require the applicant to provide probative data, not computer-generated propagation maps, which have no probative value. In order to enable this board to determine if this is a good spot for a wireless facility, you need probative data. The most common form of data is drive test data. If you get drive test data, which is very simple, they take a recording device, attach it to a phone, drive through the area, and that recording device gives you the actual signal strengths throughout the jurisdiction. That data, that actual probative data, shows you, number one, the existence or absence of gaps in service, number two, the geographic locations of those gaps, and number three, the boundaries. If and only if the county was provided with that data, would the county be placed in a position to figure out if this is a good spot for a wireless facility? Because if there is gaps in service and this tower doesn't cover the gap or only a portion of the gap, it simply means there are going to be more towers. And that's so that granting this would be entirely inconsistent with both the code, the comprehensive plan, which was latest updated in 2019, and the intent behind both. As far as the intent of the code, it's laid out right at the beginning. Section 1.2b, the whole purpose of your entire unified land use ordinance is to protect property rights and property values and minimize the conflicts among the uses of land and buildings. This case is a textbook example of a use that would conflict with the nearby uses and rights of the property owners, as supported by the substantial evidence that I've submitted. In similar vein, the whole purpose of the comprehensive plan is set forth to, quote, preserve and enhance the rural atmosphere and character, balanced by respect for private property rights and regulating development and growth. The only way to properly balance between the interest of this site developer, Horizon, and the property owners is to take into account the adverse impacts that this 15-story tower would inflict upon those homes and weighed against the need for the tower. And not just the need, but the question of whether or not this applicant has proven it needs a tower. It has to be this tall. It has to be right where they want to put it. Now, I've looked at the factual determinations made by the lower board, and I find they're without support. There is no evidentiary support for the findings. There is no probative evidence to show that there's no reason why they couldn't place it at least less intrusive alternative location. The applicant claims the other locations are not viable because it doesn't meet its standards. That's meaningless. That doesn't mean that a tower at a less intrusive alternative location wouldn't work or wouldn't meet whatever coverage needs are legitimate. You don't know whether or not it is because this applicant has not provided the data that you need to make an informed decision. So it's not on the fault of Boise County or any agency thereof. It's the obligation of the applicant. Under your code, it says they have the burden. They haven't proven any of those things. So aside from that, there is, of course, the problems with the insufficient fall zone to protect against dangers like ice fall, debris fall, fire, structural failures. I've submitted evidence of the other types of potential adverse impacts that are known to result from the irresponsible placement of wireless facilities. And bear in mind, Mr. Schneider and the other 34 property owners, they're not against cell towers in general. They're against the irresponsible placement of wireless facilities, which is precisely what the provisions of your code were intended to prevent, and is precisely why the town adopted a conditional use permit requirement in the first place, to enable the town to prevent the irresponsible placement of wireless facilities. I respectfully submit that granting this application or denying the appeal violate the code and inflict upon the nearby property owners the precise types of adverse impacts the code, the conditional use permit requirement, and your general plan were all adopted to prevent. So thank you for affording me a time to speak. If you have any questions, I'd be more than happy to answer them. Thank you.
Thank you. Okay, now are you finished with your presentation? Or
Yeah.
First appeal?
Yes,
Or?
thank you. Yes.
Mr. Chairman, you are free to ask any questions of the.
All right, I will ask one question. When you speak of federal law that's already been decided, can you cite any of that?
Yes, in our brief, I believe we cite the OmniPoint case. And this came out of the United States Court of Appeals for the Second Circuit. And in that case, the property owners were opposing the more than 100-foot cell tower that was close to their homes. And the applicant argued that the evidence submitted by the neighbors was insufficient because it was letters from the homeowners and real estate brokers' letters as opposed to appraisals. And the federal judge in that case, the federal judges in the Second Circuit said, no, real estate brokers' letters are valid. And as far as personalized letters from the homeowners, again, they're in the best position to know and understand the specific adverse aesthetic impact they will suffer. If you look at the letters submitted on behalf of the property owners, they specifically describe how it will affect them. For some of them, they might say, every time I look out my bedroom window, this is going to dominate my view. Or every time I try to entertain family on my back deck, this 15-story tower is going to loom over us and dominate the skyline. That is the precise types of adverse impact descriptions that the U.S. Court of Appeals for the Second Circuit recognized as substantial evidence in the OmniPoint case. And the OmniPoint case has been followed by other federal courts across the country. It's 16 years old and it's still good law.
Alman, any questions?
I've got a couple.
Okay.
You talked about locations and that there was no studies done on the other locations as being acceptable, or the data as far as signal strength. Why wasn't the other locations, if that's true, why were the other locations looked at and a study done with whether the signal strength or whatever would work?
Yeah, I mentioned, there's one thing I should also point out. For years, applicants have provided computer-generated maps. And the problem is they have no value because they can simply create a map that shows anything they want. It's almost like it's a drawing program. It got so bad that last year, the FCC staff decided they didn't want to accept these things anymore. So the FCC staff did testing. They did 10,000 miles of drive testing. They conducted 24,000 tests in 9 states. And what the FCC staff found was that the propagation maps that were submitted by companies like Verizon and AT&T, the accuracy of those computer-generated propagation maps range from a low of 16.2% to a maximum of 64%. And so the staff at the FCC advised the FCC they should no longer accept computer-generated propagation maps without hard data. And for the same reason they found that, local governments from New York to California are now saying, don't give us these propagation maps. We want the data. Do the drive test. Because how do we know if it's going to cover gaps? Give us the actual data. This applicant, respectfully, has not submitted any probative data at all. To the extent that they want to claim there's a significant gap in service that necessitates this tower, they should be submitting drive test data, hard data. If they want to claim that the tower is needed for a capacity deficiency, the most common form of data they provide is drop call records. If they claim Verizon has a capacity deficiency, Verizon can use its computer and print out a list of all drop calls for any specific location for any period in time. It's a few keystrokes. None of that has been submitted here. Simply put, the applicant has failed to give you enough data to put you in a position to determine if, in fact, this tower is necessary at all, much less at this location or at this height. And by the way, if it's built at 150 feet, at any time thereafter, this applicant can increase the height to an additional 20 feet to 170. And this board would be legally, the county would be legally prohibited from stopping them because of the Middle Class Tax Relief and Job Creation Act of 2012. So if the 150 foot tower gets approved, at any time thereafter, they could raise it to 150, which would make the adverse aesthetic impacts even worse.
Okay.
I got one more real quick. You said as far as evidentiary packets and that, you were talking about the broker's opinion being, I haven't had time to review everything really in detail, but do we have broker's opinions included?
Yes, they're next as Exhibit B to the memorandum in support of the appeal.
Okay, thank you.
Thank you.
Mr. Chairman, if I could just add as a local attorney, I wanted to emphasize, we're not in the Second Circuit, but it's very persuasive authority because as Mr. Campanelli has talked about, these were court cases interpreting a federal regulation. So any federal court that's interpreting a federal regulation, especially as extensively as the Second Circuit has, and as much as that case law has been followed, is very important. But I also want to underscore, Mr. Campanelli and I are both members of the Ninth Circuit Court of Appeals. We're in the Ninth Circuit. And I mention this because the applicant has made a point of this in their brief. There is Ninth Circuit precedent that's cited in the briefing provided Mr. Campanelli. And most importantly, on page 5 of what was submitted, the T-Mobile case is cited, and it's a Ninth Circuit case in our jurisdiction with regard to aesthetics being a valid reason to deny a proposed wireless facility following from the Omnipoint precedent. So I just wanted to make sure that you are aware of that in response to the question that was asked by Chairman Twilliger. And the other one is on page 9, the test articulated is from the Ninth Circuit that expressly requires the applicant here to demonstrate, and it is their burden, and that is so important to understand. It's not our burden to do these studies or bring these studies to disprove things. It's their burden to bring studies that prove these things. Both the significant gap and the feasible alternative requirement are in that Ninth Circuit case, the American Tower Corporation versus City of San Diego. So I just want to be very clear that it's not only the Second Circuit case, which has been criticized, notwithstanding the fact that it is a federal court opinion interpreting federal law and regulation, but there is ample Ninth Circuit authority. And actually, Mr. Campanelli can correct me if I'm wrong, some of the most significant decisions in this area have come out of the Ninth Circuit, and that's why you see those cited here. So I just wanted to mention that. Thank you.
Thank you, Mr. Semanko. Okay, anybody have anything else? Okay. All right, so now we'll move on to the second appeal. Jennifer Ferguson.
Yes.
Please approach the.
I'm going to be pretty brief here, and then if I have any time left, if they'd like to use it, they're welcome to, if that's allowed. Okay, so I'm Jennifer Ferguson. Thank you for allowing me to speak. I'd like to bring to attention to Brian Adams, who is here today, and he will be speaking later. He is a property owner across the location where the fire department, which is across Highway 21, and he was actually approved for a cell tower by Maverick Towers about 2 years ago. I give or take, a few months. And Maverick Tower, I actually wanted to confirm this with Maverick Towers and find out why wasn't that built. So I emailed Maverick Towers and asked, that question. And within an hour, I received a phone call back from Andy Cockrell, and he is actually the owner, president of Maverick Towers. He explained to me that they were approved to, they had approved a lot to pursue, to put the cell tower up, and they were about ready to start construction and get all that figured out. And they lost their carrier to Horizon. So Horizon came in the picture and took the carrier away, which I'm guessing it probably was Verizon or one of the big people. So Maverick Towers is a Idaho-based company. I just think that we should be aware of this because it's important to me. It's an Idaho-based company, and they're out of downtown Boise, and they pay taxes here in Boise. Horizon Towers is a California-based company. They don't pay taxes in Idaho. And they came in and took business away from Idaho. And I think that's wrong. That's just my personal opinion. The other thing that I am really fighting about is the NEPA, which is National Environmental Protection Agency, because we have bald eagles in the area. I have them right off my back porch, and I'm about 600 feet, 700 feet away from the cell tower. And I'd also like to note that it's really not going to affect my view because my view's at the cliff. It will affect my view from the front. But that's not what I'm fighting for. I'm fighting for the fact that this is wrong to the neighbors that I see every day. And I'd like to also present this one. I did present to you, but I put it in a picture form because he had brought up the fact that could you actually get a visual of what I may approach?
Please.
Okay, thank you. A visual of, this is a tower. This tower here is a tower on Warm Springs Boulevard, and it's a 130 foot tower. Sorry, I'm a little nervous.
Yeah.
And it's about 20, it's smaller, 135 feet. This is our area. I'm sure some of you are familiar with. This is the home that's right. This is where the cell tower is going to go. This is the home. There's a children's window here and another bedroom window here. That's how close this monstrous tower is going to be placed. And this is going to be times 4 because this has one carrier. They want to put one, the 100-foot tower they want to put is going to have 4 carriers on it. So that's going to be double of what this is, and double generators, double this and double that. And it's going to go this close to this house. So this is where you read those letters from the neighbors. This is the impact that they're talking about. And I just wanted you to kind of get a visual of that. And I actually submitted these in my the pictures so you can look at them, but I just kind of wanted to blow them up a little bit to really see how large this is going to be next to a home, and imagine that outside your bedroom window, and just.
Could you show that to everyone?
Yes.
As well as the camera.
Oh, where's the camera?
Camera's right here.
Yeah, it's first.
You might back it up a little bit. There you go.
And also show it to the.
Yeah, well, yeah, definitely. Anybody else? So you're welcome to. Yeah, except for these, I didn't submit, so. I don't think so. And then the other thing is I've been working with Katie Powell with the, she works for the, so nervous here, sorry. Katie Powell is a fish and wildlife biologist for the United States Fish and Wildlife Services, and her office is here out of Idaho. And I've been working with her, telling her about the bald eagles in the area and the nests, and she has recently sent me a letter on the recommendations. She recommends that it would be almost impossible for the cell tower to be put there and be able to only do maintenance or construction during outside of nesting season, which would fall within the worst month, which would be December, January. I'm sorry, I'm tongue-tied here. So it would be the worst of winter months. Would be like 2 months they would be allowed to actually be outside of the nesting area for bald eagles in the area. And she recommends that there at least be a 1 mile to a half a mile buffer but from where the nests are that are in the area. I don't know if it made sense there. And I have that letter, and she actually mentions the developers. If you'd like to have a copy of this letter, you're welcome to it. Actually, I just received it yesterday, so I did not able to submit it. The only other thing that I did personally is, so I used to, before I moved up to Moores Creek, I was a homeowner in Southeast Boise. So I figured I would get on the next door there and do a survey about cell towers and living next to cell towers. And I thought there wouldn't be any bias if I did it in an area outside of Moore's Creek. So I thought that would be more. And what the question I asked was property values and cell towers. What would you expect to pay less for a home if it had 150-foot or taller cell tower next door? And the questions that the people, 166 people voted, and the questions were, I would not buy a home next to a cell tower. 67% of those 166 people said they would never buy a home near a cell tower. I would pay less for a home near a cell tower, 16%. And a cell tower next door would have no effect on buying a home, 17%. But the whopping number is 67% would never buy a house near a cell tower. And I think that proves devaluation right there. And that's all I have right now. Thank you so much.
Can I ask you a question?
Yes, you
Before
may.
you leave.
I'm just glad I'm done.
Ms. Powell of U.S. Fish
Yes.
and Wildlife, why did she say that it's best to have a mile buffer?
Okay, this was her exact statement.
Okay.
I realized that the limited time frame might not be feasible for the work they are doing. So if the activity means building and maintenance, if the activity must occur during nesting season, then we would recommend at least a ½ mile buffer if activity is not within the line of sight of the bald eagle nest, and it would be within the line of sight. Or a mile buffer if activity is within the line of sight. So she's actually recommending that it'll be a mile. And it says, if the work must occur within the ½ mile to a mile buffers of any eagle nest within the nesting season, then the developer or landowner may apply for a non-purposeful take permit. I should also note that regardless of when the work is done, nest trees should be avoided from any physical alteration or removal. And then she also notes, I'm sure you all are aware of that the bald eagles are protected by the Migratory Bird Treaty Act as well as the Bald and Golden Eagle Protection Act. And they take this very seriously.
Okay.
That was what she said.
Well,
So,
to add on that, did she actually, did some of the biologists actually come up and do a study
No,
to see
she's
how
very
many are
familiar.
within that?
no, she did not actually come up and visually see it. I did send her pictures, and she's also very familiar with the Moores Creek, Roden Creek area. I did submit pictures of the nest that I'm aware of. In
And they
my,
are within the mile or ½ mile?
oh, they're actually closer, within like about 600 feet.
How many are they?
But how many nests? The nest, one that I'm 100% sure of is that one, and there's another possibility of another one. Yes. Yeah. I was just gonna say something, I can't remember what it was, but anything else?
Sure.
Yeah.
Okay, thank you
Okay,
very much.
thank
Ms.
you.
Ferguson. Appreciate your time.
Okay, thank you. I appreciate you.
Okay, it looks like we can open this up to public comments, which would be, no?
No.
What are we doing?
Applicant.
Oh, sorry, we didn't even do this. Sorry, we're just gonna cut you out of the whole thing.
Trying to shorten the meeting.
Great, thank you. Else doing that? Sorry. Oh, yeah. I was like freaking out thinking it was that.
Might be. It's an old building.
Technology, right?
Right.
That's how it is. Okay, my name's Josh Leonard. I appreciate the opportunity to be here. Right before the hearing started, I overheard one of the commissioners say that they've been studying for a couple of days on this, and I don't doubt it. There's a lot in the record, and I appreciate your time and effort in reviewing all this. It's definitely important, and I also appreciate the public interest, and I don't say that tritely, and say that sincerely. I appreciate the people that are willing to be here and be interested in this. I'd also encourage everybody that's here, when the county announces a ordinance amendment or a comprehensive plan amendment, to be as active in that, because that's where policy is made. That's where the decisions that lead up to today are made. I apologize for the length of my PowerPoint. I wasn't sure what they would cover in their presentation. I wanted to be prepared, so I came loaded for bear, as it were. I'm going to cruise through some of these that they didn't touch on. Yeah. User error. Gotcha.
You should leave it down.
Hey, Robert, you want
Yeah, thank you.
to come up here?
I wouldn't think so.
You guys like to take a quick break or?
We're gonna, thank you very much. Appreciate it. All you had to do was threaten a break.
All right.
Quick overview. Like I said, I'm going to breeze through this pretty quick. There's a lot of slides. Overview of the presentation. We're going to discuss the need for the tower. Why this site? We're going to rule out some alternatives. We're going to discuss federal law. We're going to discuss the compliance of this application. We're going to discuss some concerns, public safety, and then get to a conclusion. As an initial matter, this is the site, the picture of the site. This was presented to planning and zoning. I'd just like to point out that there really hasn't been any new information presented by the opponents of this tower. It's all along the same lines of what was considered by the Planning and Zoning Commission when they unanimously approved this application and granted the CUP. The lease site, as you can see, it's in green there. You can see the existing fire station facility at the front there, on the right. You can also see that house there, just above and pretty close to the property line. That's 100 feet away from the side of the tower. And I understand the tower is 150 feet, and that's 100 feet, and I'm going to come back to that in just a minute. Steve Kennedy is here. He's an RF engineer with the Wabco's Consultants, and he's going to discuss a little bit about the need for the tower at this location.
Morning, Mr. Chairman.
Morning.
Board members. So I'm a radio engineer by trade. I've been doing wireless radio frequency engineering for about 33 years. I've been in the telecom, just doing wireless. Proposed site, we've already gone through this, 134 Moores Creek Road. It's a 150-foot tower. Verizon will be the primary locator. There will be an opportunity to locate other antenna systems on the tower as well. Verizon's height would be at 145. It's a ground elevation of 3,277 feet. The coverage objective, provide coverage along Highway 21, provide in-building service in and around the community of Roby Creek, and provide coverage along High-21 towards Lucky Peak, Helibase Nursery. Now, another thing to add to this is a license protect site. So the FCC regulates any transmitters that has a license that they must provide coverage for this license within a certain period of time. So when we say provide coverage within the license, we cover POPs or population. So the FCC, in order for Verizon Wireless to protect this license for this county, they have to provide service to homes, businesses, users, population, right? So what's in and around this site? A lot of houses, a lot of population. Sites. This is a screenshot of the site out of Google Earth. You guys have some wonderful terrain up here. It really causes all sorts of pain for radio frequencies. This is the best server by frequency band, or not by frequency, excuse me, by technology. So you can see along Highway 21 that 2G and 3G service is kind of being provided in some places. There's no 4G service being provided, maybe a little bit to the north. And once again, once we get up in Idaho City. The second is coverage. Now, opposition counsel stated there's no drive tests. These are drive tests. This slide right here shows Root Metrics, which is a third-party independent company. They drive test all over the nation, and they provide information back to the wireless carriers telling them what is seen on the roads, what's seen in the drive test. Now, red is bad, orange is poor, yellow is fair, blue is good. Now, if we can look to the left, look at Boise. There's a whole lot of blue. There's a lot more sites. Look along Highway 21. There's some yellow, some fair. There's a whole lot of poor, and there's a whole lot of red. Now, there's a little bit more yellow in the area where we're at, but remember, this is license protect. Verizon has to put this up to keep the frequency bands or keep the licenses within the time period they need to, or they chance forfeiting those licenses back to the FCC. So when opposition talked about there's no drive test data, there it is. There's drive test data. Now, I can also say that probably anybody that's driven up and down Highway 21, you can know there's no coverage. It's spotty at best. And I turned my phone on and let it sit on and camp on whatever it could and kind of peeked at it every about 2 or 3 minutes, all the way up here from Boise. There is no coverage. It's horrible, right? And there's no coverage. There's capacity, all right? The opposition council talked about capacity. Well, if there's no coverage, there's not going to be much capacity either because you have to have a radio signal. You know, opposition talked about drop calls being one of the best ways to show there's no coverage. Well, yes, opposition counsel is correct. A drop call shows bad coverage. The only problem is if the mobiles can't connect to the network and the transceiver of the base station at the site and the transceiver of the phone can't talk at all, there's no drop call. So another indication beyond what is a drop call for no service is no service. If there's no service, the phone can't connect to the network, there is no dropped call. All right, this is open signal. This is mobiles. Anybody who loads the Facebook app or any other apps, there's a little, whenever you give them all the permissions to load whatever you want to load, it also loads this app called Open Signal. It's a little piece of software that says, hey, whenever my mobile connects to the internet and it connects to a network, I'm going to send back data to these servers, and these servers are going to report what the mobile see. Now, if you can look towards the Boise side, southeast, you see green, you see some red as you you start heading out on the interstate. If you look at the network stats for the area, there's not a lot of mobiles reporting anything. Why? Because they're not connecting. There's no coverage. There's a significant gap in service along Highway 21 and in the areas around where this proposed site is. Okay, so this is the modeling software. Now, opposition counsel talked about the models not really making a lot of sense and people don't want to use them. It is a tool for the RF engineers. We use it. We use it all the time. These are models provided by Verizon's local RF engineering guy, right? These are telling us what's going on with the proposed. Where is the site covering? The site's covering the houses, the population. It's what it has to do. It has to cover the populations to protect the license. It has to cover the population because who uses the phones? When you guys told everybody to mute their phone or turn it off, a whole lot of people within the room got their phone out, turned it off. So we know there's users, they just can't connect in this area. So we have a significant gap in coverage. This is the proposed site. This is the amount of houses it's going to cover. This is the coverage it's going to provide. Now, the other guys, the competition, T-Mobile, look at what its mobiles are reporting. Red, bad service. They're reporting just horrible connections. It's not there. There's no service. What's AT&T reporting? Same thing, no service. Both of these are drive tests. These are drive tests from units that are sitting inside these vans and they're being driven around all over the United States and they're showing bad. Now look at what T-Mobile looks over to the west in Boise, a whole lot more green, blue, right? Look at what AT&T has to the west, a whole lot more green, blue. There is no coverage on Highway 21. It is horrible. There are sections of Highway 21, there may be coverage, but up in this area and north of here and south of here, there is bad coverage. Here's AT&T's open signal. So these are users that are on the AT&T network. They can't even attach. It's bad. Here's T-Mobile users. We've got some attachments here and there, but a whole lot of red. It's not good. So here's the east-facing elevation to scale. One thing to note, I was in the airport, got my rental car, started talking like, why here? Well, I explained the reason. She goes, oh, you're getting a tower built? Where's it at? I said, you know where Roby Creek and Highway 21 is? Oh yeah, I go up there and visit my parents all the time. I really don't like the fact that I don't have wireless service along Highway 21. That makes me nervous. So even the car rental agencies, people inside Boise know there's no service on Highway 21. Any questions?
Nope.
As Steve mentioned, this is an elevation and this is to scale. This is an engineer's.
Hang on just a second. I guess.
Yeah,
Colin said a
we'll
question.
slow it down here because it takes me a second to get my thought together on a
Yes,
question. And you said there's no coverage all the way up to Idaho, up to Idaho City. It's a red area.
There's some spots here and there that you might get on a hilltop. You might get a site where coverage. T-Mobile has a tower south on Highway 21 that you get for a little while, but it's
because we do have areas all through Idaho just like that, Stanley to here.
yeah.
But the issue is you covered housing. We're trying to provide for providers in housing.
And
Most of those are fixed phones. Why is it a priority for cell coverage for housing areas?
the FCC regulates that whenever a license is granted to a carrier, that they are provide service to the population base. Mobile service, mobility service along Highway 21 is just as important. But one of the things the FCC looks at in the license application, what we do when we provide coverage and show we've covered the POPs, it's population. They want to show that there's ability for users to work in their house, around their house, leaving their house, going down the street and everywhere
Well, with
else.
that being said, is this tower going to give connectivity clear up to Idaho City with no dead spots in between here and
No,
there?
sir. This is only one spot. And like I said, it's license protect. So this is going to be one of the few that
Okay.
would be needed to provide service all along Highway 21. I've done designs and looks. It's going to take about 5 to 6 towers to get continuous coverage up Highway
5 to
21.
6 towers?
Yes, between Idaho City and the interstate.
Isn't elevation a factor in the
Yes.
towers
Elevation is always a
and
factor.
degrees of the repeaters and transmitters?
There's
So you're saying you can't put one that'll cover most of that area based on elevation?
no, because you're going to get dead spots in and around because wireless antennas or frequencies work
Yes,
like
line
our
of
eyes.
sight too,
Yes.
on that frequency.
So you have to, the
But
antennas actually have to see the area. So there's going to be holes and or loss of coverage all along. Areas that aren't going to be covered unless you have more transmitters up and down the highway. So this is one of the few that's going to be required.
Can you speak to the license? I mean, when you talk about populations, what does that mean exactly? I mean, does it have to be in the center of the population or just have to serve the
It
population?
has to serve, it has to provide us the population with a certain amount.
How
of
long
area.
does this license go? I mean, is it,
They have a build out within this license, I think of 10 years.
and how old is the license?
The license they're trying to protect is at 8 years, I believe.
how many years?
So there's 2 years left on the license. What happens if it expires? What do they do?
They would lose the ability to transmit, and that license would have to turn off
And they
any
would,
carriers within that license boundary,
Would
any
they
operations.
would probably just reapply that, wouldn't they?
That part I don't know. Carriers typically don't like to let their license go because of the amount of money they spent. In the latest auction for the C-band licenses, which occurred a little over a year ago, all the carriers spent $84 billion to acquire those licenses from the FCC via auction. That's a lot of money. I don't think they're going to want to give that up. And so they're going to build out and make sure they protect those sites and they protect those licenses.
Did you examine any of the other alternative sites
Yes,
yourself?
sir, I did.
Can you speak to that?
So there was one alternative, or actually two alternatives, one to the south that was brought up. There's,
We're actually going to get there in just a second. If we can.
Okay,
you don't mind.
that's fine.
I apologize. I apologize. It's just in the. sequence
Yeah,
of
that's
the
fine,
slide.
as long as it gets answered.
Any other questions?
No, that was my question. Give him a thunder.
Again, just back to the scale picture here, showing the buildings there. What makes a viable site? The attorney on the phone from New York, or on the Zoom from New York, mentioned that these are our standards. These are just standards for what makes a viable site. This is what we need. I want to highlight one of these, the second to the bottom. Utilities must be nearby. That's not because of cost. That's because if we run utilities across private properties land, we have to get their permission. So if we're on the top of a hill and there's 10 private owners between us, the likelihood of getting permission from everybody is pretty low. As we said, the proposed site's the only viable site. We listed in our initial application packet, in our supplemental application or our supplemental letter, 11 other sites that were considered. We sent letters. We've been working on this for about a year before we even submitted to try and find a suitable site in this area and a viable site. And this is it. Steve's going to talk a little bit about those two that you asked about.
All right, so I went back and I looked at alternative analysis. So once again, opposition brought up a site that was 0.8 miles further north of the proposed. Its latitude and longitude are up there. The primary objective is the town of Roby Creek population, right? Highway 21 is going to be covered within the section the site can see, like you said, line of sight, but the population. 8/10 of a mile further north than the proposed, down in a little bit of a crevice that's not going to do quite as well. This is the area. You can see the red pin to the north. That's the proposed site. There's a red pin to the west. That was the original. If I have a pointer.
There's a laser on there.
There it is. Okay. All right. So there's the alternate that opposition brought up. This was the original search ring right here. And then this is the, if I can name it right. Our batteries might be going. Yep.
It's not showing up.
Yeah. So this is the opposition site to the northeast, the first opposition site, and the original search ring, once again, up on the higher elevation areas, which I can speak to in a moment. Then the site in Roby Creek, or the Horizon proposed tower. There is a site, the Maverick Tower, that opposition spoke of a moment ago. That site is on a ground elevation about 100 feet less than what the Roby Creek proposed site is. With it being 100 foot less, you have to get at least 100 foot up of tower before you can even compare to what the existing site is. So to even get ground elevation, you have to build a 100-foot tower and then build another 150 foot on top of that to get the same kind of propagation.
Can you do that?
Can we build a
Is that possible?
build a 250 foot tower? So it's possible to build a 250 foot tower. Now you've got a light, right? If we're talking about visual effects, yeah, it's regulated by the FAA. So you have to put a light. It may be painted. It could be a red light beacon. It could be a strobe beacon combo. It depends. Plus, you're not going to get coverage up to the northwest quite as much along that stretch of Highway 21 because there is that larger elevation where the primary searching area was that's going to block that. The line of sight is not quite as good as the site on the east
So
side.
that area just moving like a, 500 yards, 1,000 yards doesn't have any increase in elevation.
Say that one more time. I'm sorry.
From that second proposed site, is there any, if you walk 500 yards in any direction, is there elevation that would
Yeah, there's
compensate for that?
there's still, it's in a lower area by the 100 foot. So even if you do move, I think that property is not that large. If you move east and west on that property, you still cut that nice big hill where the primary search ring is sitting. That's going to pretty much block a whole lot of stuff.
And I guess another question I have, which for most of these locations you looked at, county property, federal property, personal property, private.
Yes, sir. You can talk to that better than I can. So here's the RSRP coverage proposed, provided by the Verizon Wireless RF engineer. You can show that, see that the population red is in building, green is in vehicle, blue is open field. So you can see the impacts terrain has within the area. So this is what the proposed site would do. When he propagated the alternate, you can see the change. So the same RF levels, indoor, in vehicle, open field. So you see that the proposal that was north of it by 0.8 of a mile, it's not going to do as well. It's not going to provide in-building service for in-buildings for population. Primary objective was the town of Roby Creek, Highway 21 is an assist south towards the helibase and as north as far as it can go. The site located farther north does not provide in-building service within the search ring. The alternate site would not meet the objective and require a second tower to be built pretty close, like much closer than if the proposed site's approved and then we step north and we step south and we find the next terrain spot that makes sense and we can get as much propagation up and down the highway as we can. Like you said, it's line of sight. If there's no line of sight, it's not going to be seen or heard by any mobile. Any other questions, concerns?
Anybody?
All right.
You've been briefed by, yeah, I'm
Could
sorry.
you go back to that slide before?
You bet.
So Andrew's property, would that be Cecil D. Andrew's property?
No, it's not.
Okay,
Brian, I think Brian's here.
just curious.
Yeah, no, I don't know if there's a relation.
No relation.
It's funny. Telecommunications Act of 1986, I'm going to cruise through you. You've probably been briefed by your legal. We'll come back to that in a little bit. As I said before, application complies with all standards and conditions. And it's in accordance with the comprehensive plan. And in particular, There are two comprehensive plan provisions and goals that actually address specifically cell phones or phone service. It encourage development of cell phone coverage and wireless internet coverage for all of Boise County and promote improved phone service. It doesn't say just allow. It doesn't say just begrudgingly permit. It says encourage and promote. A denial today would not be either of those. It would have the opposite effect. Uh-oh. There we go. Comprehensive plan again, projected population and development growth in Boise County will require a corresponding expansion of public facilities and services. One thing I want to point out is that these provisions have been in the comprehensive plan for a while. I was reviewing written comments that were submitted to the board, and a lot of people said they came here to get away from the city. A lot of them since, 2015, 2017 that have moved into the area to get away from the city. What they don't realize is that as more people move into a neighborhood and create a population center, they bring the city with them. And cell towers are part of that bringing the city with them. And in this case, it's been in the comprehensive plan for a while that the city is going to be, the county is going to be promoting and encouraging cell tower development. That's been there for them to see, as well as this acknowledgement that it's going to require corresponding expansion of facilities and services. One of the appellants mentioned that the deed hadn't been provided. I just wanted to note that the deed isn't required by the county's land use ordinance. It's actually just a note on the application. You can breeze through that pretty quick. If you need to see the deed, there it is. We provided an affidavit of legal interest, which is what is required, and provided that. The second concern, that the fire district owns the property, and we agree, and so do the members of the board of that fire district to support approving our application. And I point you to the letter that they submitted in favor of that. Again, okay, so concern 3, why not put it on public land? They incorrectly alleged that public land wasn't selected because of financial reasons. That's just not the case. None of those viable site considerations that we can take to a court includes finance. It includes finances. We can't tell a court, well, it was too expensive. They don't care. So we don't. That's not one of the considerations. Concern number 4 mentioned that there are better options. That's just not true. As I said, cell towers follow people. People live nearby, which means that you need cellular coverage in that area. To your point a few minutes ago, landlines. Landlines in Idaho are down about 65%. Since the advent of reliable cell coverage, and part of that is through the cutting the cord and trying to limit the amount of bills you're paying. One of the notes that I've reviewed about this area is that there are a lot of Wi-Fi calling. When the power goes down, unless there's a generator, there's no calling on via Wi-Fi because it requires power. So at the bottom there's just no benefit in operating a cell tower away from where people are. Concern number 5 was safety. Mentioned 145 cell tower workers have died. 121 of those deaths were no fault of the worker, and 74 are still being investigated. That just doesn't add up. Also, no time frame or area. It could be worldwide, could be United States. But more importantly, in 2019, the federal government Bureau of Occupational Safety and Health, or no, it's the Occupational Safety and Health Administration, published the most dangerous jobs in America. Included on that list, just as some examples, cashier, mining, of course, machine operators. Number 1 was logging workers, which in this area you can probably imagine is why that would be. But not on the list, cell tower workers. In 2019, there were 5,333 deaths in the workplace. Only 4 of those were cell tower installers, and 1 of those wasn't due to a fault. It was because of a wild animal attack. Most common cause of death in the workplace, transportation incidents, meaning that it's more dangerous to drive to a cell tower than it is to climb it. Mentioned winds.
You're coming up on your time.
Thank you very much, appreciate it. Mentioned winds, we pulled the data from the National Weather Service. The highest wind gust, which isn't a sustained gust, just a 1 gust, was 30 miles per hour at the site of the tower. Mentioned lightning. Cell towers are grounded, and cell towers don't climb, or cell workers don't climb cell towers in lightning or winds. Aesthetics. This is actually from the appellant's brief, and it's an incorrect statement of the law. I don't think Mr. Campanelli understands that Boise County doesn't have a comprehensive really, system of multiple zones, that it's a single zoning district in which almost every use requires a conditional use permit. And it's, he mentioned in a couple of places in his conversation that these court cases that were decided based on aesthetics. In all of those cases, the city or county where they were decided had a really comprehensive list of regulations for aesthetics. And required the types of studies that they said he didn't have, or that they said that we didn't submit. He's asking us for evidence that's not required by Boise County Code. He also mischaracterized my argument about the broker's price opinions. And I'm going to wrap up here really quickly, but the broker's price opinions, I didn't say they're not sufficient. I'm saying they would have been sufficient, but they violate Idaho law. In order to not be considered an appraisal and not have to get an appraiser's license, they have to comply with about 9 or 10 different standards, and none of them did. One came close, only missed a couple of things, but it missed the two most important. And that's a disclaimer that it's not an appraisal and that they should consult an appraiser if they want an appraisal. So not only are those illegal and in violation, they just shouldn't be considered. Let's see. I'm at the end of my time. I'll probably hit some stuff in rebuttal. I appreciate the opportunity.
Okay.
If you have any questions, we'd be happy to discuss those.
How much more did you have to go of the stuff you would?
I have 2 more points, but I can bring it up in rebuttal.
Just go ahead and do the 2 points.
Okay, I'm just going to not use the PowerPoint and just hit them really quickly. There was a lot made about bald eagles, and nobody loves bald eagles more than I do. I grew up. My wife likes to say I grew up farm adjacent, and we had bald eagles on our property near the lake. We are required by the federal government to submit a NEPA evaluation to determine whether there's an impact. I'd note that in the letter that was presented to the board from the appellants, it didn't say what I think they thought it said. It said that if there is an impact, we'll be required to either impose some sort of mitigation or take some steps. And that's exactly what happens every day on cell towers all across the country. We can't build a cell tower here if the NEPA report comes back and says that there are bald eagle habitats that would be disturbed by this tower. The letter that was read into or referenced today during argument didn't talk about operation of the tower. It talked about construction of the tower. That's exactly the type of condition that would be placed on us by the federal government, that we couldn't construct during breeding season or mating season. That's exactly the kind of thing that they do that stuff for. Last one, the Andrews property. It wasn't that it was described as though Verizon poached that site. It wasn't that at all. The carrier determined, based on their engineers' determinations, that site was not feasible to provide the coverage that they needed to provide in the service to retain their license. I'd also note that 2-year period for the license expiration, that they need to have the tower built within that 2 years. They got an extension. Previously, it was to be done by the end of last year, to have it built and up and running. And obviously, this process has taken longer than that.
Any questions?
How often do you actually build on federal? I mean, we got a lot of forests around here. Why is that not a priority over, when there's no houses in federal, but it's close enough?
You answered that question yourself by saying when there's not houses, but it's close enough. In this instance, it's been determined that the RF engineering doesn't work to provide coverage to the houses if we put it on federal property. Love putting it on federal property because it doesn't result in a hearing like this, where we're making neighbors mad. Love that, and would do that if it were a possibility in this instance. It's just not.
What's the requirement for what percentage of the population should be covered? Is there?
Question. I don't know the answer.
There has to be an answer to that.
I'm sure.
The numbers.
I don't know if it's a percentage.
You don't know.
It's a number.
What's the number?
Okay.
It's at least 90% of the population within the licensed area by the build out term.
What was the licensed area again?
It can be depending on the license boundaries, which all license boundaries are different, whether it's the 2100 megahertz license or the 1900 megahertz license or the 700, 850, they're all different boundaries because the FCC awarded them differently, made it very difficult. The best way to look at it is county level. It's within the county. The license area for this license, I believe, is 2 counties.
So this in Gem County or Elmore or?
I think it's the county north that had the issue. The Idaho city site that's here provides.
So 90% of 2 counties is what you're saying.
Yes.
Not for this one tower. It's the.
No, I get the license itself.
The license itself, population within the area. So within the county, there's X population. We have to cover at least 90% of it.
Okay. Okay. Anybody want to take a break or should we just plow through this?
I do fine.
We'll do 5. Let's do a 10-minute break. Let's come back at quarter to, or 10 to 11.
Blame it on me. Then everybody will be pretty good.
Okay, coming back from break, we are now going to move into the public comment section. In this section, we will allow everybody to speak for 3 minutes. We'll start with those who support, then those who are neutral, and then those that are against. Now, some of you folks put, I don't want to comment, which is fine. We just got those here, but some of them didn't mention it. So if you want to comment and I don't call your name, then you need to speak up. Okay. So Sherilyn Davis. Want to come up here, Sherilyn here? Davis, okay. She left? Oh, okay, well, we'll go back, and put her to the end of the list. Okay. Okay, Scott, you probably don't want to do the public, do you? Didn't think so, okay. Nathan Bowers?
Yep.
Come right up here, please. 3 minutes. And Commissioner Sturm here has your 1 minute warning sign there.
Mr. Chairman?
Yes.
In order to maintain a clean record, can we ask whenever anybody comes up to testify, if they can, in the microphone, state their name and their address?
Okay.
Hello, Commissioners. My name is Nathan Bowers, 7 Joy Lee Circle, and I'm the chief of the Roby Creek Volunteer Fire Department. So really the only thing I wanted to just to bring up to you today is about 3 years ago, we had a fatal rollover accident on Roby Creek Road. And from that incident, I mean, I lost quite a bit of sleep after that. It messes with a person's head if you're not used to that for some reason. But the only thing that got me to be able to sleep at night was taking action going forward. So there's a few things that I view that we need to have. We need to have better communication. I need funding. I need people. And I'm nervous and I forgot the last one. I need training. So that's the whole reason why I've talked with the community about funding. We've increased our dues. And we got to a point where the people are like, I don't want to pay more dues. We've talked about taxes. I don't want to pay taxes. So to me, this was a win-win. I was like, I get some funding. It helps things out. I get better coverage for the service area. That's about all I've got. So.
Okay. Did you have a meeting prior to making this decision with the community, or how'd that work? I'm curious.
So actually, what was it, last April, end of April, early May, I sat down and I started going through the phone calls from our fire department, and I think there was probably 150 to 200 voicemail messages. And so when I got to 2020, I started taking notes, and I ran across a phone call from Horizon. I contacted them, got a little bit of information. I brought it to the fire board. We talked about it. Even though we were not in the Morse Creek Rim Ranch HOA, we contacted the Morse Creek Rim Ranch HOA to make sure, are we in or are we out? Where are we? And notified them in May of last year that this was our proposal. This is what we were looking forward to. In that meeting, we had discussed, trying to get community input. We tried to get the annual meeting for the HOA brought up to June instead of July so that we could speed the process along. But I did ask the HOA at that time that, knowing that there was a signing bonus for signing on to this loan, or sorry, I signed loans. Signing for this tower contract, I'd asked him, is like, if we are at risk for losing this signing bonus because we're waiting for public input, what do you want me to do? Do you want me to sign or not sign? And I got the okay from the HOA board to sign the contract at that time. So.
How much was the signing bonus?
At that point in time, it was $5,000, but I think what we actually got when it down the road, it went to 10,000.
Okay, and what is the contract per year that the fire department gets paid?
It is for the tower with one carrier. It is $800 per year. Oh, that's right, $800 per month. Sorry, $800 a month. And it's weird math, but it's for 35 years. So the first, it's what was it, 6 years, the first one, and then it's every 5 years after this for 36 years. And it has every contract period, it goes up 10%.
So you can, oh, okay.
Right, so it's auto built in, 10% increase every month. And then if the additional towers go, or additional carriers go on, it's $400 per month per carrier, plus the additional. If the tower goes on with 4 carriers right off the bat, it's a little over $1 million into the community.
Over a period of.
Over a period of 35
years.
years, 36 years.
That goes to the HOA or?
No, it goes to the Broken Creek Volunteer Fire Department.
All of you.
All of it goes there. So,
I would think some should go to the community if it was accepted, put that plan in.
I think that,
Nope.
okay. Thank you, sir.
okay, thank you much.
Stephen Kennedy. Sherilyn Davis. Still not back.
She said she had to go to work.
Okay,
Oh,
well, heaven forbid. I'm gonna go to work. Okay. I thought I saw one that said neutral in here. Did anybody put neutral down that wants to speak? That wishes to speak? Anybody? No one? Okay. Then seeing none, we'll go to those against the application and then we'll get on with it. Norman Semanko, another attorney. Paul Pierce.
Yes.
Please approach the podium, state your name and your address.
My name is Paul Pierce. I live at 15 Edgemere in the Morse Creek Rim subdivision. I'm just right up the street from where they want to put the tower. Yeah, Boise County wants to encourage and promote, but responsibly and unobtrusively. And I can see cell phone towers, but again, unobtrusively and responsibly, not right out in the middle of a south-facing slope with no trees, no cover, and in the middle of a subdivision. That's just pollution in my eyes. This spot has nothing. It's just obtrusive. Maybe put towers in a tree-filled area, like a north-facing mountain, not in a south-facing west slope like we live in. Hide it amongst the trees somewhere up in the top of the mountains. My subdivision, everybody I know, we don't have any problem with service. We use our cell phones for our Wi-Fi's, just like they say we do. We get 4G service. I've never been without it. Even when the power does go out, I have a generator and most of my neighbors have a generator that they use. Either when we use for hunting or whatever, we just use that if we need it. Most people also have landlines to communication, so nobody really has a problem with that either. Those maps the applicant shows with the red dots, they're very, very misleading. They must have took those red dot surveys before they started using the cell phone tower above the high bridge by the nursery and the helipad. That's a huge tower. That's not even 150 foot. That's lower than 150 foot. There's T-Mobile, and T-Mobile everybody has T-Mobile has service from Hilltop all the way down almost through past the upper bridge and through the twisty turnies there before you come around the corner. Okay, so yeah, Verizon might not have service there. So that's misleading. T-Mobile does. Okay, they could easily put another antenna or a transmitter on that tower to get service. And not only that, I can see, if you've ever been over there, come around down that corner and you look right through that canyon, you can see the top of Wilderness Ranch mountains and houses up there. So they could put a tower up there to cover whatever it doesn't cover down by T-Mobile. So anybody needs an emergency system, anybody has T-Mobile, they can just go right there and make a call anyway. The placement's also in a very dangerous spot that they want to put it. When it does fall, pretty much any direction it goes, it could take out 2 different houses that have children. Almost time. Okay, almost done.
1 minute.
They can take out the fire department. They land right on top of that thing. Now we don't have fire protection. Or it can also, the biggest thing too, besides children, they can take out our water facility, leaving us stranded with no water, which is no plumbing and nothing. And who knows how long that would be to destroy that water treatment facility. And then I got a picture here. And the question is this what Boise County wants? A huge 14-story tower out in the open in every single subdivision? And I want you guys to take a look at this if you can. I was going to submit it, but
Hey.
Landon, are we?
Are we allowed to look? at
Oh,
this
hold
or
on.
not?
Yeah, we got it.
If it's being used for demonstrative purposes, it can be viewed. It's not going to be allowed to be marked as an exhibit and entered into the record.
Yeah, I just wanted to have a mental image. This is the 200 in town.
Those are
Okay.
houses.
Do
Where's
we want
that,
that in every single subdivision in Idaho?
where's that
Boise
one
County?
located?
This one's actually on the way to Ontario.
Oh.
Out
Turning from our break. Break. Is that you?
How bad?
Okay, so this is going to be the time for rebuttals. The time will be determined by myself. Or we want to hear everything that everybody has to say. So we'll begin with the applicant rebuttal. And commissioners, this is the time to ask questions.
Thank you. Appreciate it. That's Leonard again, for the applicant. Do you mind if I take off my jacket?
Please, yeah. Thinking about taking off my shirt. It's so hot in here.
Oh, please don't.
If we'd done weather's this good, we should have done it outside.
Getting.
For sure. Thank you again for the opportunity to speak. I just want to remind the commission today that all of the issues that you've heard and all the information you've heard was raised at the Planning and Zoning Commission level. And that they, after considering that, unanimously approved the application and issued the conditional use permit. They considered everything, and they included some conditions of approval, and I'm going to get to those in just a moment. Now, however, the appellants, the people that filed the appeals, their strategy is threefold. The first is they're demanding to see evidence from Horizon that's not required by the Boise County's uniform land use ordinance, or excuse me, unified land use ordinance. I get that wrong all the time. The second thing that they do is that they attack the facts and evidence that are in the record, but they don't provide any additional evidence of their own. And I'll talk about that in a minute too. And then the last one is that they raise red herrings. They talk about things that just don't matter and just aren't before the commission today. I'm going to cover each of these three. First, the appellants were demanding drive tests. They said that the drive tests are where the data is. That's the best way to know of these pockets of lack of coverage. We provided drive test data to the Planning and Zoning Commission. It was on the screen here too. We provided it to you as well. It shows that all up and down Highway 21, there are gaps. We talked about that this tower won't cover all of Highway 21. There are a few towers needed, but that this one is in a particularly good spot. One of the people testified that it would require 11 towers, and that was true with the tower on the Andrus property. When you move the tower from the Andrus property over to the Roby Creek Volunteer Fire Districts or Department's property, it shrinks that number, and you need less towers along the road. Then the appellant started claiming that we needed to submit a view study. A view study is just not required by the county's land use ordinance. The second prong of their strategy is to attack the evidence that's actually in the record. And I want to be clear about this because I think this is a crucial point. Because all of the actual evidence, or not all, most of the actual evidence in the record was presented by Horizon. Rather than presenting evidence of their own, they've just criticized and complained about the evidence that's there. One of the key points on that is that concerns and comments aren't evidence. They're just concerns. I know Commissioner Holmes, or I believe you were in law enforcement. You can't go to a prosecuting attorney and say, I've got concerns that this guy might commit a crime. I want to lock him up.
Reasonable suspicion.
Reasonable suspicion, right? You have to have that suspicion and evidence, right? You have to have more than just a hunch. And in this instance, all they've said is we're concerned about safety. We're concerned about coverage. We're concerned about other locations. All of these things. And the only evidence has been, this is the site. This is the only viable site. They've questioned what other sites have you looked at? We showed them. We showed all of the people that we sent letters to and that we've been emailing or telephoning to get to try to procure other options. This is it. This is the only site. And like I said, it reduces the number of towers that are required along Highway 21 to fill that gap. There's no evidence in the record that contradicts the evidence from Horizon that there is a significant gap in wireless coverage at this location. There's no evidence of other reasonable, viable locations for this tower. And I can tell you about the Andrus Tower. If that worked as a site, it would already have a tower on it. There is no evidence of any viable alternatives. There's reason for that. Horizon's team spent a year, or almost a year, working with its RF engineers and working with Verizon's RF engineers to find sites. And this was it. The question was even asked by appellants, why weren't studies done on any other locations? I can assure you they were. On every site that had the potential and met those criteria, they were doing RF studies for Horizon, Verizon. They were trying to find a site that worked. This is it. Moving on to the third of the three prongs, the irrelevant information. Again, nearly every person who spoke asked the question, why not somewhere else? And some even suggested putting the tower far away, up on the top of a mountain. Tops of mountains look flat from here. Tops of mountains are very rarely 50 foot by 50 foot flat area where you can put a tower. And even if you do, you've got to cross private property and usually numerous owners' private property to be able to get there. So there are access issues. Also, you don't want a tower on the top of a mountain. That's an architectural term called skylining. And it's when a man-made structure pokes up over the top of a mountain from a distance, it's really visible. It's visible from a longer area or wider area too. Most of all, the site at issue in this matter is the one that we've proposed. It's the relevance and it's the important one to be considered. And the only evidence in the record of siting was submitted by Horizon and says that this is it. The next irrelevant evidence I want to talk about. A photo was shown of today of a 200-foot tall tower. That's not even the type of tower this is. That's called a lattice tower and it's self-supporting. And it would require lighting. It would require a lot of other different facilities. That's not what we're talking about here today. There was also a question asked, why doesn't the county regulate the power output of these? Because the federal government would get mad is why. The federal government does that regulation. The FCC has regulations that are very specific about what the county can and can't do and what Horizon Tower as a tower operator can and can't do. Other irrelevant information, I'm not even going to go into it. I'm just going to say that the taxable status of the fire district is irrelevant today. I appreciate the desire to have transparency, but the outreach that the fire district conducted with the HOA didn't need to happen. They're not a part of that HOA. That property is not in the HOA. They did it for transparency, to have that contact. The transparency that Horizon is doing is engaging in is submitting an application, holding a public hearing over at planning and zoning, and then and then having a public hearing here where everybody can see what the application is and then make comment on it. That's due process and it's transparent. The other thing that's not relevant is where Horizon's headquarters are located. They're in California. I'm not in California. I'm from Idaho. I live here. Like Mr. Semanko, I practice law in the state of Idaho, and I've done so for almost 20 years. Speaking really quickly about the Roby Creek Volunteer Fire Department, please don't take this out on Nathan. Nathan's a good guy. Nathan's board signed a contract, and Nathan is fulfilling his responsibilities under that contract. This isn't Nathan's fault. If you want to yell at somebody, I'll make myself available afterwards. You can yell at me. And I mean that. Nathan's a good guy. He doesn't deserve it. And it's not his fault. I want to move on to two last arguments. The first is safety. Actually, no, I'm going to reverse it. I'm going to talk about property values. There's thorough evidence in the record from Horizon. It's in our brief, in our supplemental brief, and in our brief on appeal, that towers don't negatively affect property values. Now, that's not what you'd think. You'd think that a tower would negatively affect property values. Valbridge Property Appraisers, which is the largest independent appraisal group in the country, conducted a, I'm sorry.
You said to ask questions during, so we, okay, I hate to interrupt you, but the 3 studies I said didn't have anything to do with Idaho or Texas.
Correct.
They weren't our state.
You're right. Those studies, Valbridge's studies.
And I'd like to see one for that specific area again.
Absolutely. So, and the reason those aren't submitted is because the tower hasn't gone in yet. So
I'm gonna ask you another question. If the tower was going in the Eagle, how would it be received?
I'm going to answer your first question first, and I'll come to that one. Really good question. The answer to your first question is about the surrounding areas. We also provided, and I'm not an appraiser, so I didn't provide you with conclusions. I just gave you the data. But the data is in there from 4 sites in Idaho, 1 cell tower site in Boise County, and 3 in Valley County. And what we did is we took similarly situated properties in each of these places, 1 near a tower and 1 not near a tower. And we charted or looked at what those assessed values were over the 2 years before the tower went in and 2 years after the tower went in. And the difference, negligible, if any, on property values. The Ada County assessor sent an email when, this is about a tower in Eagle that I worked on. He was asked by staff, Ada County staff, tell us what the effect on property values of a tower is. He said, initially, people get really upset about towers. And everybody thinks there's going to be, but the market doesn't show that. There's been little, if any, movement in market values as a result of tower location from the Ada County assessor.
Interrupt. On that note, you have market. Idaho is the #1 growing place in the country. Okay, and I looked at the data that you provided, but there's really no way to extrapolate what the meaning out of it, because if something goes up 57%, how do you know that it wouldn't have gone up 67%? How do you address that? Because the data there was no way to tell that.
You're absolutely right. And I'm going to get back to your question about Eagle in just a second, but let me take this one and come back around. So what we did is the only way that you can do that is providing a comparison to the growth of a similarly situated property that's not near a tower to the growth of a property that's near a tower, and to see if those 2 line up. Because there's not a way to take the same property and figure it out both ways and you just come up with a theory. So we took the actual values and they match. They go up the same. Now there's some of this, right? A couple of months after the tower goes up, maybe it dips or whatever. But over the course of a year, just 1 year after the tower goes up, and going back to Eagle, the tower that we worked on in Eagle, an appraiser came to Ada County and said, it's going to affect the market value of this home by 10%. It's going to knock it by 10%. The tower goes in, the next year's assessment comes out, and it's gone up 100%. So 100% difference. I know Idaho's on fire in terms of the real estate market, but that 100% difference in what it was and what it is, the Eagle market isn't a 100% in 1 year rapid increase. So that's the other way that we track that is with market index. Going back again to Eagle. Eagle, just like anywhere else, nobody likes cell towers, right? Nobody wants a cell tower nearby. Nobody does. I know enough about cell towers that I'm not worried about it, and I wouldn't mind having one nearby. People say that's because they're your client. Sure, you can say that all day long and paint me with that brush. I'm telling you honestly, it doesn't bother me because I see them all over the place and they kind of fade into the background, just like buildings and roads and highways and everything else that's out there. With that said, people don't like cell towers, but they like cell coverage. And in this case, they don't just like cell coverage. They've gathered in an area where the federal government has said to Verizon, you have to provide cell coverage or you lose the license for 2 counties. So Verizon's come in and said, okay, here's what we need to do. This is what we're going to do. We're going to contract with Horizon, which is a tower locator and tower operating company, to come in and build a tower and lease a spot to Verizon. Would I want a tower in my backyard? It doesn't bother me. Yes, but would a lot of the people I know? Probably not. But I know a lot of people who live near towers, especially in Eagle with as fast as Eagle is growing. So property values, back to that. Really, the only information that was provided by the appellants as far as values was from the realtors who sold them their properties. There's an inherent conflict there when the person who sold them their properties wants their properties to maintain their value. The other issue is that they violated Idaho law. They performed appraisals and reached conclusions that appraisers are supposed to do. Brokers can give price opinions. Brokers can't do appraisals, and they failed to include some of the elements required to make those not illegal in those documents in those that they provided. The second thing I want to talk about is safety. The comment was made that the FHA won't underwrite property within a tower's fall zone, and that's partially correct. What they don't tell you is what a fall zone is. We think of a tower as being like this, and that it's going to do this, right? It's going to go down. It's going to fall horizontally. That doesn't happen. Towers don't fall horizontally. In fact, if you ask a tower engineer, or most cities have engineers because cities have a requirement for a fall zone. Like Eagle has a fall zone requirement. Ada County has a fall zone requirement. They have these fall. Most of those fall zone requirements are 1 foot of setback for every 10 feet of vertical. And that's because there are engineered into these towers to make them so when they fail, if they list too far, they don't fall over. If they list too far, they drop.
You're saying they never tip over?
No, I'm not saying never, because I'm sure there have been instances, and I'm not a never statement.
Ask loggers how logs fall.
I'm sorry, what?
Talk to some loggers and you'll get a bunch of rebuttal on that.
Well, probably true. But with that said, this one is by Horizon Tower, and the engineer letter is in the record. Both have said that neither has said, how do I put this? Both Horizon and the engineers that build the tower have said they've never had a tower fail, let alone tip sideways. I'm going to knock on wood just to be sure, but they haven't. In this case, with a 150-foot tower, the fall zone, engineered fall zone for the tower will be 15 feet. If you look at the perimeter of the 50 by 50, the tower is 25 feet from each of the outside walls of that secured, for lack of a better word, compound. Tower is designed to fall within that. Even if it, and this is something I forgot to bring up earlier and want to raise now. When I looked at this site plan, and when we looked at this site plan after the last hearing, we said, you know what? It is only 100 feet from that neighboring house. And if I'm in that neighboring house, I don't want that there where it's 100 feet. I want it at least 150 feet away. I'm asking you to include a condition of approval that says that we will relocate that so that it's 150 feet away from that house and not within that fall area. If it were, it's unlikely, but even if it were to tip, that it doesn't smack that house. I get that, and I understand that. And we did, after we left that last hearing, and that was a concern, we mentioned that and got together and said, we think we can do this on this property. Generator was raised, the noise of a generator. One of the conditions of approval is that it can only be tested at certain times. The need for a generator is there because without the generator, you don't get the service. And without generating batteries, you don't get service while the power's out. When it's running, there's a noise requirement that the FCC has for the generators that are at these sites. It can only go to 60, and most of the time it has to run between 40 and 60 decibels. And decibels don't compound, right? If you've got 4 machines running at 60, they don't necessarily all of a sudden become 240 decibels. I understand why you think that, but I'm not a scientist. I barely passed my physics class, but it's not that compounded. It's
right, but if you were at NASCAR and there's 1 car in the track as opposed to 10,
it's a lot louder.
I would agree that
it's a lot louder, and not just that, but it's because they're 2 cars. It's prolonged, right? There's more,
sure,
because they're going right. Yeah, no, absolutely, I agree with that. There's a condition of approval on this for to require it to only run during certain times, the generator, or to only be tested, excuse me, during certain times, and it'll only run when power is
Will
up.
it be 4 generators? Is that correct? Or
So right now, if it's one generator at 60 dB, opposition had stated that if there's 4 generators, it's going to be 240 dB. The human ear, humans,
I'm asking if there will be 4.
not right now. No, there's only one carrier.
Okay,
There's one
will there be
generator.
4? Is there potential to have?
There's potential to be 4 if 4 carriers attach. Yes, sir.
Oh, okay. Each carrier will have their own. Okay.
Yes, sir. But remember, it's not going to be 240 dB. It's going to be
No, I totally get that.
69 dB.
Yeah, yeah.
And along those lines, the water is a water district building that's there, has a generator too, from what I understand.
So 5 generators.
So 5 generators. Also, though, we're by asking you to include a condition of approval, moving it 50 feet back, we're reducing the impact that would have on that on the neighboring home. This is one of those. The other thing you can do is require a solid fence as opposed to a chain link fence, because that'll knock down the sound a little bit. You can definitely do that too.
Are these going to be diesel generators, I assume?
Yeah, most likely. I'd turn to the engineer.
Yeah.
The last thing I want to talk about is public safety, and I didn't get to it in my earlier presentation. There are a couple of things in the record that I wanted to re-review. And the first is the letter from the fire district itself, from the board, and all of them were signatories on that letter. I'd ask you to look at that and to see what they're talking about when they say that it will help them. It's not the primary purpose of the tower. The primary purpose is to provide service for Verizon customers. The secondary purpose is to enable, and at no cost to the fire district, to enable them to put their transmitters up high enough that they can get some coverage around there too for their handhelds, in addition to the financial benefit. But in particular, I want you to read that letter because it talks about incidents that could have been prevented. Maybe it's up Roby Creek, but at least it's not that it wouldn't have had to go as far to get a viable cell signal, right? They wouldn't have had to go all the way to Idaho City or all the way down to the dam or to I guess the Hala base has one. If you're one of the carriers that has an antenna on that. I'd also ask you to read. Bill Lendvay submitted a letter, and I think he's a Micron worker or a Micron employee, or was, maybe he's a retiree. But what he didn't tell you in his letter, and he didn't even mention it, it was funny when I went through it and saw this. He was involved in an accident on 21, and he hit an elk. Maybe it was a deer, I think it was a deer. He hit a deer and couldn't get a signal, and his car's there, damaged, he can't move it. And he had to get in the car with a stranger and ride down to where there was coverage. And this was pre-Hala base. No, and I don't say that that's probably a big deal here.
Okay, everybody.
But would you want your daughter? But would you
Yeah,
want
we're
your daughter
recording this. Hang on,
climb? I mean, Mr.
hang on
Lindbergh.
just a second.
Sure.
We have to be able to hear what this is because this is testimony. So let's keep it down. Go ahead.
Mr. Lendvay can handle himself. But if that's your daughter, or if that's I don't know, if it were one of my kids, I wouldn't want them getting in a car with somebody just to go make a call. I just wouldn't. And then the last thing I'm going to cover is the Andrus property one more time. There's not a tower there because it doesn't work for the tower or for the cell companies.
Has your company, has Horizon done a study on that?
We did do an RF study on that and to determine where it would work. He mentioned the elevation gain, and I appreciate that. Elevation gain means slope. Can't be sloped. You don't want to put a tower on too much of a slope. It's got to be a 50-foot area that's flat, and you're doing cut and fill to get that on that property.
You know how far that is from the highway?
It's not very far.
Okay.
Are you saying,
Just on the other side of the.
you saying it will not, I'll address this to your engineer. Are you saying without a doubt would not work on the other place? I mean, engineering, everything else done, you're saying it will not work. I want it on record.
I'm saying at that location, by what Maverick Tower gave, by what opposition gave, that site would have to be 250 foot tall in order to match, closely match, or to even attempt to match what the proposed site is, and it's going to have a fall off of coverage to the north along I-21. And it'll be less coverage than what this is. I can show a picture if that's okay. Can I? It's
You can show a picture for demonstrative purposes. It
Okay.
won't be admitted into the record.
understood, sir. So if you look at the picture, this is the location of the tower that opposition brought up. You
Right.
can look at the terrain. You look at the terrain over here, it's 100 foot taller. Then you've got this nice ridge up here where one of the candidates that we tried to get, right? And it's much higher. So this site is going to be limited farther north up Highway 21. Okay,
What if
so
they do 250 feet?
it's still going to be limited because, you can't see over the hill, line of sight. Yeah.
Everybody else exactly describe what you're saying.
And Mr. Kennedy, this you also,
Yes, sir. Yes, sir. Sorry. All right, so. This is on. So once again, this is the site that was brought by opposition. So this is the location that Maverick Tower is looking. This is the proposed light horizon. There's a 100-foot difference in ground elevation. Once again, remember that if we're going to get at least at the same, we're going to have at least 100 foot on this tower. And then we're going to go another 150 foot, but because of the terrain in this location, it's going to be hindered north on Highway 21. Once again, like Dr. said, if it was a tower that was going to work, it already been built.
Can I interrupt for just a second? I've tried to refrain. I've had people behind my back while I was speaking whisper liar here. I've had people in the back here.
We're ignoring it. We see it, but we're not.
The hand gestures. I just need to put it on the record as an objection. And I
Okay.
appreciate that.
Noted.
Okay, thank you very much. I appreciate that. Did you have any, jumping back to it, do you have any?
No, it's just like, and being retired and working with communication too in the military, all up, UHF, VHF, HF. I know line of sight, and I know that area you're talking about. I'm a hunter, I get all over the county, I've been all over these mountains. I know for a fact there's better places, in my opinion, based on flat, everything you're looking for. You may not have the infrastructure with the power there, and it would cost more to bring it in. But companies like Verizon can afford it. It's the way I look at it, if they're serious about it. And when the people that put me in office to represent them, I've got to listen to, and I'm not totally against the federal government. In some ways I am. But I don't like when I was briefed and told, you will vote for this unless you can find good reason and enough to not vote for it. That's wrong to say to me or anybody else that represents anybody that's put in office, as you will vote for this unless you can find any reason why you can't vote for it with good facts. And you're selling us on your facts that you see, but in your opinion, HF, were you doing that by yourself? Was there any other person engineer with you? Is this your opinion?
Well,
Is
this
it
was
a-
Maverick, wasn't it? You're using the information from Maverick. You didn't do anything yourself, right?
So what I did was, there's two engineers involved with this, the
Mhm.
Verizon arc engineer and myself.
Okay.
So what I did was I looked at what the Verizon engineer did. You saw that in maps. It's part of your package. That's what he generated. This was his choice. This is his primary area he wants to build. Right? So he's made the decision. He's the one who had to make the call. I support him. I validated and looked back at what he did as well and saw, yes, it covers the population. It also covers Highway 21. Then I went back and I did an evaluation of the entirety of Highway 21. I looked at what's it going to take to cover Highway 21. And I look back and depending on the area, right, it's like a domino line of sight. If you're too far away, you lose the line of sight. So if you go back and you look at the T-Mobile coverage drive test, you're going to see what that T-Mobile does down south and what it provides. It's in the data. It doesn't go very far. So it's going to take 11 sites. I went back and I re-engineered and I found depending on the location, if we can get in the right spots, we can do it in 5 to 6 sites and all of Highway 21 is covered.
What's your
Six.
range between towers? Based on power output and that, I mean, what are you
Well,
looking
it
at?
depends on the situation, the terrain like we're talking about. You're talking maybe 4 to 5 miles at best. That's the best site you can get, and that's the one that's on the south side of the rim, down by where the dam is, up right on that peak. That's one of the key players in it, right? So it depends on where the site is and what the terrain is around it and how 21 cuts through everything. It's all dependent on line of sight. And once again, it's like a domino. If that Maverick Tower that T-Mobile has down south covers, maybe 1.5 miles, 2 miles, and you start designing them that way, yeah, it's going to take 11 sites. Do you want 11? Do you want 11 on the highway, or do you want 5 or 6?
Which is more
Or
expensive.
4 or 5?
11 is obviously more expensive.
Yes, sir. And it's going to impact more people, more stuff.
Also, not more expensive necessarily to Horizon, because Horizon's not gonna do all these towers. You're gonna see some from Maverick, you're probably gonna see some of the national companies coming in.
But it's obviously as a general rule, if you're gonna
Yeah, oh
do
yeah,
6 as opposed
More
to 11.
infrastructure.
absolutely.
So this is the singular horizon site. This is the site we're talking about. This is going to have an impact. The next site to the north, depending on the site getting approved or not, it's going to be driven by what the next proximity is and what the coverage is going to require. If it goes in the right spot, it goes on the right peak and it gets right on between 2 corners and you got good line of sight, hey, great. If it doesn't, oh, well, the number of sites go up because now you have to adapt. It's not something it's as each site gets built, that helps drive where the next ones have to go. And that's all dependent on, like what Joshua said, what is leasable, what is zonable, what is capable as a site versus not.
Just continue.
I'm essentially done. I do want to just really quickly mention that and with all due respect, Mr. Holmes, I'm sure that he didn't, that your attorney didn't say that. You have an excellent attorney, and I'm sure he just looked at the legalities of everything and advised you. But I just want to go on record as saying.
I'm not saying what came from my attorney.
Okay, well, I understood, but it sounded, you said that you were advised, and so I assumed as attorney. But what I want to say is, and I appreciate your personal experience in this, and I appreciate what you bring to the table. The only evidence in the record, which is what you have to base your decision on, the only evidence in the record is from an RF engineer who actually did the studies at these different sites and determined that this is the only one that works.
And that's all in here.
Well, yeah, and it's been here today.
Okay.
Thank you.
You finished? Okay, great. Hang on, don't sit down yet. I've got a pile of questions. Don't put your coat on, that's for sure. Okay, so Exhibit 1A.
So there was a little bit of confusion about exhibits, and the reason was that there's 2 appeals.
Yeah, that was a little bit confusing.
Yeah, I'd need to see what.
Well,
what
this
day
has to do with the Fish and Wildlife. And this is from,
Well, he's thinking
Anyway.
about, was it NEPA done?
Yeah, NEPA is required by the federal government.
It's completed.
I don't know if it's completed or not, and here's why. It's not. Typically, they like to wait until there's a zoning approval to contract with the scientists and spend a lot more money on the site.
NEPA's take 1 to 2 years from what I understand.
I don't know that
Right
that's true.
now,
NEPA's done as a filing with building permit. It's a requirement typically by building permit departments. Before you get a building permit, NEPA has to be shown and approved. But
it could be ways off.
it could be.
Well-
It depends on what the NEPA says and what the environmental company says.
And that's the point I was gonna make. If the NEPA comes back clean, then it's really pretty quick. But if it comes back and it has a bunch of mitigation and doesn't let them build during a certain season, then you're absolutely right.
so it appears that the opinion of the Fish and Wildlife, and I'm just going to read part of this.
Can I
because-
ask a quick question? Can we pull up my slideshow? It was one of the slides I didn't get to. And we can,
Okay.
I'll look at it if that's okay.
That's fine. As long as it sheds some light.
Yeah. I apologize for interrupting.
It's okay. It hasn't been yet.
Hmm.
We'll get there. Page 4.
I have page.
Well, let me read it to you. Okay, so this is in reference to nesting and the breeding season and so forth. So about halfway through this, it says cell tower will more than likely cause disturbance to bald eagles during nesting and foraging in the close by areas. Other predatory birds will perch and hunt on tall tower, providing clear view of bald eagle's nest in the lower trees. The bald eagle will need to expand energy defending the nest, causing a huge disturbance to care for their eagles. The tall cell tower structure will more than likely cause injury or death during nesting season by disturbing and interfering with the successful natural habitat, nesting and roosting territory. That would be a clear and absolute violation of the Bald Eagle Protection Act.
Okay, that's great. And read the first line of that again.
Cell tower would be more than likely to cause a disturbance.
More than likely to cause a disturbance. The purpose of the NEPA, if NEPA comes back and says that that's not just more than likely, if that's going to happen or could happen, not even a will happen, it's if it could happen based on the NEPA that gets reviewed by the federal government, then they can't put the tower. It's pure and simple. And the reason why the distinction is, and just to mention it real quickly, that is a letter that's based on a constituent inquiry about an area, right? It's not a specific scientific. And on that same
That's
topic,
not a constituent saying that. That's the United States Fish and Wildlife or whatever the heck it is.
I'm saying a constituent reached out to them to obtain that letter. It's a response to a constituent inquiry.
What's the relevance of that?
Because it's not a NEPA done by a scientist. It's somebody who's opposing
Okay.
a cell tower.
Okay.
So yeah, I mean,
So if you have one of the biologists come out and
Yeah.
say it's definitely, you have an issue.
Okay.
And that can be at the state level, correct? Of state,
it is
it's a federal bird,
correct.
but we have our fish and wildlife that overlap.
You're absolutely right.
Did you have to obtain an additional permit because of this or no?
An additional permit.
Yeah, it's
So that-
page 11.
So the NEPA is
Sure.
required, and what it happens, it rolls into the building permit process. So once again, like you said, the NEPA covers federal and state law because the environmental scientists, that's what they look at. They take into account both federal law
Okay.
and state law.
Fair enough.
On that same letter, though, I want to point out the bottom quote. Talks about the breeding season. And I know it's a bald eagle, so it's protected under the Bald Eagle Protection Act,
Mhm.
but it notes this is not a bird of conservation concern in this area. And then up above, it goes on to say, these are previous pages, habitats should follow appropriate, or the tower going in should follow appropriate regulations and consider implementing appropriate conservation measures. That's all done as part of that NEPA process.
Okay. You guys mind if I just continue and just blast at this and then you guys can have a turn, or do you want to?
No, go ahead.
Okay. Okay, hang on just a second here.
This is all governed primarily through by the FCC. Everything we're doing pretty much is driven by that agency, correct?
Largely the communication side of it, absolutely, and then they review the NEPA as well as the state agency.
And I don't know the legalities. I don't know what under states' right, what authority we have to.
That's a question for the attorney for sure.
Okay. Sorry this takes so long. I just don't want to rush through this. I want to have a thorough. Okay, so Exhibit 14. Let's see. The National Institute for Science, Law, and Public Policy found that 94%, this is on page 9 of Exhibit 14, found that 94% of its responders to a survey said that cell towers and antennas in the neighborhood or on a building would impact how interested they would be in a property and how much they would pay for it. And 79% said of those respondents said that they would not under any circumstances buy or rent a property within a few blocks, while 88% they would never buy or rent a place that had a cell tower or a group of antennas attached to it. How do you respond?
I don't know what that policy group is. I don't know what their goal is. I don't know what their basis is. I don't know what the parameters of the survey were. I don't know what, how the question was asked. What I know is the facts that are in the record, and the facts that are in the record.
I believe this is in the record. Is it
It
not?
is, but it's a survey that doesn't say anything about how the methodology of the survey. I mean, I could come in today and say anything about a survey, a Facebook survey that I do, and call it a survey. This doesn't have any, I mean, there's no evidentiary value or support to it. It has the effect of an opinion.
Okay, fair enough. Let's see. So has there been any studies about fumes from the generators? If we're going to have potentially 5 generators going and they're diesel, I just have a hard time believing there's not going to be a fume problem, especially if you're 100 feet away from it or right next door.
Yeah, and
How do you address that?
I don't know the answer to that. I don't know if there's been a fume study necessarily. I know that they're required to comply with the, not just the requirements that are related to the environmental piece of that, but also to the FCC's additional requirement.
Excellent. Okay, Exhibit 23 speaks of reasonable access. We're going today. Let's see. Hold on a second. Yeah, reasonable access. Can you describe what that means? It seems it's like a broad statement. Is it reasonable to who?
Isn't my Exhibit 23, what is that?
It's Chief Deputy, Ada County Chief Deputy Assessor Brad Smith, who you also
I quoted, yeah.
cherry-picked this because you didn't read the bottom of it where basically he says just the opposite. I'll read that for you. In regards to the impact on property values, I would take the same view I had a few years ago. While it becomes very emotional for owners when they are installed, the overall effect in the market is very minimal. In fact, we have not been able to find any measurable adjustment in the market. And then the part that you didn't highlight, he continues, of course, if you had two lots exactly the same with the exception of the tower in the rear, and they have the same asking price, I know I would buy the one that doesn't have the tower. So I'm sure there is some impact on the market.
And I can, if Brad, he first provides the evidence answer, which is there's no evidence of a fluctuation or a difference in the market. And then he provides his opinion on whether he would buy a house. It's okay, so you can't sell to Brad. I mean, I know that sounds trite
Nope.
but
You're making your argument.
yeah, he first gives the truth about it and the evidence, which is we've not seen any fluctuation based on towers in the market.
Okay, so on that same exhibit, well, what are we talking? 23, right? Yeah, same exhibit. Page 13, I think. No, it's page 15. 13, White Hawk Circle states that the reason you didn't do it there was that Wilderness Ranch HOA said that they would litigate. What's the difference?
What do you mean?
I mean, why?
They
I
were?
mean, they weren't. The HOA simply said, we don't want it. Well, I guess what's the difference between here and there?
Because here we have the Federal Telecommunications Act that's on our side and makes it so that when we have proven a couple of different things, we're more likely to win a lawsuit. Up there, they have a CC&R that says it can't be commercial. We're less likely to win that case.
Okay, fair enough.
Yeah, they called me and asked me and I reviewed it.
Okay. Was the site suitable then?
Yeah, the site was in terms of being a potential viable site. Again, I'm not an RF engineer, but I know that it was that they were actively considering it until the letter from the HOA.
Sure.
I don't think they ever signed a lease, but I think it was viable for sure.
Question on, when you've had this much contention and there are people that live in real close that have concern, have you ever considered working with them to buy their property?
Well, first, let me add a little bit of color to your question. Every cell tower application is this contentious.
Well, I mean, to the point where somebody's living within a certain distance and feels very strongly about it to alleviate problems if there's only 1 or 2 people and that's it. Have you ever thought about sitting down with them and negotiating?
To buy their property?
Yeah.
I haven't had to because the influence of the cell tower, the impact of the cell tower I mean, you build something on, if I build anything on a property, if I'm in Eagle and I build a car wash on a property that's, a couple miles from my house, maybe not a couple miles, but within a reasonable distance to my house, that's going to impact my property values. Everything impacts something somehow. So if I was just extending that out, if I were to have to go and negotiate with my neighbors every time I wanted to do something on my property, to buy their property, whether it was I wanted to wash my car or I wanted to have, put a shed in my backyard. And I understand that this is a cell tower, not a shed.
Yeah.
But if the requirement was that I go and buy a property around that, it wouldn't fulfill the goals that Congress put into place with the Federal Telecommunications Act, which were to spread, and not just Congress,
Federal government.
but you too, the county, encourage and promote cell towers or cell coverage, which means cell towers. That's in your comprehensive plan. So if you are doing that, you can't be requiring somebody to go and buy property all the way around to create a buffer to make sure that it, I mean, it just
That's
isn't
why I asked the
feasible.
question. I want to know if they've ever even.
I don't know that they have. I know that the applications that I've been involved with, and I typically only get involved with the hearings, not the site acquisition, but none of them that I've worked with have ever involved acquiring the adjacent property.
I know they had some in the, and you probably look at case law because you're an attorney and I'm not, but in the tornado zones of the country where they've had issues where they put them up and then they become big lightning rods. Or that's what I was talking about, some that did topple, which you can Google because of the tornadoes. Natural events. Is this an earthquake proof tower? We have earthquakes here.
Right, and we don't have tornadoes, thankfully,
Yeah.
but we do. They are required to meet building code for these types of towers, and they're also required to meet a really strict high ANSI standard.
Because I think that's above our pay grade and our planning and zoning for the, something like that for a earthquake.
Agreed.
Based on the height and the construction of it.
Agreed. It's not before the Planning and Zoning Commission, but it probably is before the county engineer, and would be for a building permit would have to meet those and would review those engineering plans.
Each site, each tower has to meet or exceed ANSI standard, TIA standard for construction. So
What is it?
ANSI, ANSI, and TIA.
Oh, yeah.
Those are the two standards that engineers work all over for the United States. Those are the standards, and it's done at a state level.
And they're inclusive with natural disasters and earthquakes
Yes.
and everything.
Yes,
And
it's required. It's a requirement for them to be able to handle that.
And that standard's mentioned in my brief too, and also in the engineer's letter.
Okay, just one or two more questions is also in the ULO. Let's see, for section 4.3, number 3, let me read that for you. May be operated and maintained to be harmonious and appropriate in appearance with the existing or intended character of the general vicinity, and that such use may not change the essential character of the same area. You think this isn't going to change the character of a 150-foot big tower?
It says the use won't change the character of the area. The use is providing a cell signal. The tower, the building, that's what it says, the use.
We're just answering words now. Okay, and what about number 9? Let's talk about that just briefly and then I'll shut up. May not result in the destruction, loss, or damage of a natural, let me start over. May not result in the destruction, loss, or damage of a natural, scenic, or historic feature.
So
The scenic, I mean, people do come to, I know I came up here, one of the reasons I don't want to be in the city. And I have a piece of property, 6 acres, and and I do have a view. And if it was obstructed, I would personally have a problem with that. How is this not doing the same thing?
So the way that reads, it says that it doesn't destroy the feature, not that it doesn't destroy the view of a feature. It doesn't destroy. And I know you're saying I'm parsing words, but words matter in this context because words are what end up in court. And I'm not saying that as a threat. I'm just saying that that's important. And in this case, it says, so if we built this on a scenic feature and destroyed that feature by putting this tower on top of it, 100% can't do it.
And you're not doing that, how?
Because the place where this tower is going, where it's being built, isn't a scenic feature. It's not that 50 by 50 foot area. And let me put it a different way.
What's behind it is
You
not the
come-
same feature. Folks, you can't have any mumbling. This is all being recorded. And we have to get this on recorded.
I understand what you're saying. And I'm going to take it a little bit different direction. Every time a building is built, it destroys somebody's view. Somebody's view. And especially if it gets more dense, right? And especially in a larger city where I'm building towers or I'm going height. Here, if I build a barn, it's going to impact somebody's view. It may not block it entirely. It may not, and this doesn't block any views. It doesn't block any views. It may be visible in a view, but it doesn't block any views. It's narrow, it's tall.
So,
Not quite as bad as Windmill Farm, but close.
It's not quite as bad as a windmill.
so
farm.
what you're saying is the scenic part is not damaged because of the 50 by 50. You're saying it has to be damaging of that 50 by 50, when in my mind, of course, the scenic view is behind it is the actual.
And if that said, if it said does not affect a view, but it says does not affect a scenic feature.
What's the difference?
A scenic feature is what I'm
Valley or river across the way or.
I'll let him
No,
answer.
if I put, and this is an absurd, I'm trying to think of a good example for you, but it's an absurd answer. If I put a tower on the nose of Teddy Roosevelt at
Are you guys doing that?
no, of course not. No, he would get upset. At Mount Rushmore, that's destroying that feature. If I put a tower in front of, 3 miles away, so that from one perspective, it obstructs a portion of that view or a couple degrees, I'm obscuring the view of that feature.
So the citizen's opinion, like the one
Same
lady
thing.
that has a house that's right behind it, that has to look directly at the tower, that's not in consideration.
It absolutely is. And that's why, and that's why after the last hearing, when we go back and look at it, we say, let's move that a little bit further away. But it's not blocking a view. It's not a 12-foot tall or 12-foot wide by 150 feet. It's a narrow pole that goes up. It's not the lattice tower.
I
that you
know,
saw.
but that's a personal opinion too, based
Sure.
on that person's perception.
Sure. No, you're absolutely right. There's not a scientific way to answer the question.
Okay.
Would you agree that regardless of the data regarding property values, would you agree that the perception of that could potentially affect the value of the property?
Tell me what you mean by the perception of the tower.
Well, yes. I mean, I can tell you right now, my perception is that it would. I wouldn't want to buy, I can tell you right now, if I had to look at it, I probably wouldn't buy. And I'm sure I'm not the only one. And who cares? I guess my point is, regardless if the data shows that, the perception by people who think that, it's been widely spread, you know what I mean? Regardless if it's evidence or not, that alone can affect the price or not.
Oh, yeah, absolutely. The perception of the house is being
So
haunted.
in this case,
Sure.
potentially, it could affect the price of the property, correct?
You're asking me a hypothetical, and yes.
But yes, you're
potentially-
agreeing.
Potentially, absolutely, absolutely. And the evidence doesn't bear that out, but I would also argue that it's not just that the evidence that doesn't bear it out. It's also that as I was riding with I rented a U-Haul truck, and I'm riding with my son in the U-Haul truck, and he looks over at the door and he sees the handle for the window, and he goes, "What's that?" And I look at him, are you kidding me? And then the other day we're talking about it, and he says, "Dad, do you remember when you were a kid and you used to have to, yourself?" And I was like, when I was a kid, have a cell phone? No, cell phones are new. It's within your lifetime. Kids have grown up with cell phones, and they don't have the same stigma. And as they get older and start buying property, it will erase that perception, even though that perception has been disproven many times, and not just in the 4 major market studies, which are persuasive, but again, not Idaho, but also here in Idaho with the different studies that have been
Sure.
performed. The facts don't bear out the perception,
Okay.
but even to the extent that there is a perception,
Right.
it's diminishing over time.
So all I needed to know on that.
We got done with this.
Huh?
We got that attorney too.
Okay. Just a couple more, if you don't mind.
More attorneys,
Yeah.
more attorneys.
Yeah, if you know what they say, if the lips are moving.
You'll get three opinions.
I had to throw that in.
No, I don't want to get into that. Never mind. I was going to ask you about attractive nuisance, but never mind. Okay. I think we've covered almost all of this, so. Okay, you guys have any more questions?
No.
You take 5. You have anything else?
I don't. I'd like to take a
I'm
5.
gonna give everybody, okay, let's take 5 minutes. And everybody in here, if you're gonna wander The important thing here is we get this all recorded without a bunch of mumbo jumbo in the back. Okay? Coming back from break, 10 after 2. We are going to now hear appeal number 1, the rebuttal from Eric Snyder. Okay.
Good afternoon. Welcome back. So it is critical to me as an attorney representing the applicant that I persuade you that the appeal should be granted and the CUP be denied, but it is equally important that I make sure that if you choose to deny it, you do so in a way that complies with the Federal Telecommunications Act of 1996. Contrary to anything you may have been told otherwise, you have very broad power to deny this application. One of the problems is that there have been a number of misstatements of fact and intimations that are completely inaccurate at best. And so I need to address that. One thing that I need to address is the fact that this applicant has now placed you in a position where under federal law, you, the board, must make 2 specific types of factual determinations. If you fail to make either type of determinations, this applicant would be able to bring an action under the Telecommunications Act to void any denial you might issue. So I want to talk about those and the lack of evidence, because this applicant has failed to provide you with the probative evidence you need to make the factual determinations that federal law now requires you to make. So the first type of factual determinations you need to make are determinations under your local zoning code as to whether or not this application meets the requirements for a CUP. The good news is under federal law, the applicant doesn't get to tell you anything. They don't get to say whether or not this proposed 150-foot tower across the street from a neighbor's house is or is not going to adversely impact her property value. You and you alone as a board get to make that factual determination. You and you alone get to decide what evidence you will consider, and of greatest import, you and you alone get to determine the weight to be afforded the evidence before you. So by way of example, let's talk about the adverse impact on property values. The applicant comes before you and says, you know, the appellant's evidence is no good because they are really illegal appraisals. Nothing could be further from the truth. They are professional opinion letters that are handed down all the time and submitted to federal courts across the country. And unlike the evidence submitted by the applicant, they pertain specifically to this proposed tower and the actual effects it's going to have on the actual homes that are right there. Now, by contrast, the applicant has submitted some reports where it claims shows that cell towers being in close proximity to homes don't affect values. As an initial matter, none of the homes in their studies are anywhere from this jurisdiction. But even worse, that analysis doesn't provide you the data you need to ascertain if it has any relevance here. There are many things that affect the value of properties. You have no way of knowing, as you review that now, whether or not there were other changes to any homes that affected the purchase prices. As you sit here today, do you know if any of the homes they pointed to had new kitchens put in, or bathrooms, or renovations, a dormer, an in-ground pool? Nor do you know if the towers they talk about actually have a view of the tower. That report, I'll call it a report, has no probative value because it is impossible for you, given the limited information provided by the applicant, to ascertain if that offers you any probative evidence as to whether or not this tower in this town by these homes will adversely impact the property values, as professionals in this area have told you. You and you alone get to make that determination. You get to determine the weight to give the broker's letters versus the report submitted by the applicant. Another thing that I had to stop, and I couldn't believe applicant's attorney said this, but the applicant's attorney said in terms of safety and fall zone, cell towers don't fall over. I respectfully submit that is patently false, but I'm not going to ask you to take my word for it. I'm going to ask you to look at Exhibit C, which is attached to the memorandum. Now, I've had many photos of cell towers laying over, as opposing counsel says never happens. But I chose this specific photo for a very specific reason. It was a brand new 165-foot cell tower built at a firehouse. And shortly after it was built, this brand new tower went from being 160 foot tall to 160 feet long, and in the process, crushed the fire chief's vehicle, the same fire chief that had signed the lease for the cell tower. So when the applicant tells you that cell towers don't fall over and you don't need a sufficient fall zone, I submit to you, believe your own eyes, not my words, not his, but think about what it would do. If it crushes a fire chief's vehicle like that, think about it, what it would do to a neighboring property or anybody who happened to be standing on the neighboring property. In a similar vein, the evidence of adverse aesthetic impacts is clear. You are allowed to take into account your own personal knowledge of the area. I don't think there's any question. You put a 15-story structure this tall, this close to residential properties, along with all of the generators and the noise and the fumes, it's going to have adverse impacts and especially adverse aesthetic impacts, which again is a perfectly valid legal ground to deny the application. Now we get to what's the most important part, and here's what it is. One of the constraints the Telecommunications Act of 1996 imposed upon local governments is that it says local governments cannot prohibit or effectively prohibit the provision of personal wireless services. This applicant knows that. And for that reason, they've made two representations to you, which are not supported by evidence. First, they represent that a carrier has a significant gap in personal wireless services. And number two, that this proposed installation at the location they want it and the height they want it is the least intrusive means of remedying that gap. Why are they saying that? They're saying that because if they prove both of those things, then you must grant the application for the conditional use permit, even if it violates your code. The problem most local governments get into is they don't make those factual determinations. You must. The good news is you and you alone get to make those determinations right now. And if you make the determinations based upon the evidence in front of you, federal courts are loath to overturn your decision. So this applicant has falsely represented not once, but twice, quote, we provided drive test data. That is absolutely not true. And I'm going to prove it to you. What is drive test data? Why do you need it? What does it do? When a company like Verizon comes into a town and says, hey, we have gaps in coverage on Highway 21. We have significant gaps in coverage. Here's our proof. They do a drive test and they provide hard drive test data. What is drive test data? Drive test data is the actual recorded signal strengths along with the geographic locations of those signal strengths. In other words, Verizon will come in and say, you know, this is pretty mountainous terrain. In order for us to provide wireless coverage to your population, we need a minimum signal strength of minus 98 dBm. That's what we need. So we drove through the area, we recorded the signal strengths. Here's a printout of the recorded signal strengths. And then they'll also give you a real drive test map, not what you saw from this applicant. What you saw from this applicant was a canned map from a company, I think the name was Root Metrics, and it said coverage map, which provided you no evidence whatsoever. First of all, it had 3 colors. Okay, great. What do the colors show? There's no legend on the map to show you what the colors show. In a real data-driven coverage map, there's a legend, and the legend says things like this. There are green areas. In the green areas, the signal strength levels are range from negative 95 dBm to minus 98 dBm. We have good coverage. The orange areas are from negative 99 dBm to minus 102 dBm. We have moderate coverage. And then the red areas are minus 105 and beyond, weaker coverage. That's where we have no coverage. There's no legend on their map because they don't have any drive test data. They didn't give it to you because they don't have it. Not only that, look at the map. What do they portray the map to be? Because you have no idea what it is. It's a coverage map, okay? For who? Is it a coverage map for Verizon or AT&T or Sprint? You have no way of knowing that. More importantly, is it a coverage map for 3G service or 4G service or 5G service? You don't know that because they haven't given you the data. The bottom line is they have provided you with 0 drive test data, which would enable you to determine, number one, they actually have a significant gap in personal wireless service. And when I say they, I'm not talking about Verizon. As far as I can tell, Verizon is a site developer. They don't provide personal wireless services. You can't get a phone contract with Verizon. You can get a phone contract with Verizon or AT&T or Sprint. They have not proved that an identified wireless carrier, A, has a significant gap in personal wireless services on Highway 21. They haven't provided you with direct evidence of where the gap or gaps are, or much less the geographic boundaries. Now, I'm not saying that there are no gaps, and it's not the appellant's obligation to prove that there are no gaps. Quite the contrary. For this applicant to say federal law requires you to grant this application, the applicant has the sole burden of proving they have an identified carrier has a significant gap in personal wireless services. And this proposed installation right here is the least intrusive means of remedying that gap. Applicant's attorney kept saying there's no evidence on the other side. We don't have to provide evidence. They have the burden of proving it to you under both your code and federal law. The reason it's important under your code is what's called a smart planning provision. It's designed, among other things, to minimize the number of towers you need to provide personal wireless services. You've had discussions about that on the record. It is impossible for you to ascertain if granting this application would be consistent with smart planning and would minimize the number of towers you need because they haven't given you the data. If there are gaps and this tower doesn't cover the gap or doesn't cover enough of it or a portion of it, they're going to need more towers. And that's why you should be asking them for the actual drive test data, and they haven't given it to you because they don't have it. They never did the drive test. They bought the data from a third party. They have no idea how the test was done, what data was used, nothing. Now, ironically, the applicant complained as far as the survey that was taken about who would buy or not buy a house near a cell tower. They didn't know the methodology. Well, I couldn't believe he was saying that because you don't know the methodology, assuming there was one, that was used in their real estate reporting. You have no idea how they chose the properties for which they wanted to quote the prices, and you don't know anything that might have otherwise affected the prices other than simply the square footage, the date of sale, and allegedly a view of a cell tower. You have no idea if those homes that sold for higher values actually were in view of a cell tower. They're not in this jurisdiction. So those are some of the basics, but I implore you, you must make two types of factual determinations. You must make factual determinations as to whether or not it complies with your requirements under your CUP. And I respectfully submit they don't. It's going to have an adverse impact on aesthetics, no question about it. The evidence is there. It's going to reduce property values, no question about it. The evidence is there. It clearly lacks a sufficient fall zone. And granting the application has not been proven to be consistent with smart planning because you have no idea if you're going to need 11 more towers because this would be an irresponsible placement of a cell tower. And under federal law, you must factually determine whether or not they've proven to you that an identified carrier has a significant gap in personal wireless service at a specific location, and that this proposed 15-story structure at the precise location they wanted, at the precise height they wanted, is the least intrusive means of remedying that gap, and there are no potential alternative locations. You must make those decisions. You are empowered to make those decisions, and you alone get to make them. I think that's really all of the things that I wanted to cover. Just give me one moment. I think that's all. If anybody has any questions, please. I've been handling these cases in federal court for 30 years. I've seen every case where, oh, by the way, two other things. As I mentioned earlier, if this 150-foot tower goes up, at any time thereafter, they can increase the height by an additional 20 feet and you are powerless to stop them. I thought I heard one board member mention that perhaps someone had suggested that you lack authority, that the Telecommunications Act of 1996 somehow ties your hands and you have to grant the applications unless you can come up with an excuse not to do so. That's absolutely false. The very first paragraph of the Telecommunications Act of 1996 is paragraph C7A, which is entitled General Authority. And under General Authority, Congress deliberately preserved to you the general authority to regulate the placement of wireless facilities. As long as you issue a written decision, it's based upon substantial evidence of the record, which is merely sufficient evidence as might support a reasonable mind finding the determinations you did, and you make all the factual determinations you must, both under your local code and under the Telecommunications Act, you are well within your power to deny this application. So I respectfully request that you do so. I will ask one final note, because maybe there were some mentions of litigation or not. I get retained by local governments all across the country. Sometimes when an application is denied, an applicant will file a lawsuit under the Telecommunications Act. And many local governments are fearful, saying, oh my God, they'll bankrupt the town. Nothing could be further from the truth. When local governments are sued under the Telecommunications Act and they lose, the applicant does not recover a penny. The municipality does not pay them damages and does not pay them attorney's fees. The only relief they obtain is injunctive relief in the form of an order from a federal judge ordering the municipality to give them the permit they need to build the tower. In this case, there's no way this conditional use permit should have ever been granted. I believe based upon the facts and the evidence you have before you, the lower board made a mistake. And so I respectfully request that my client's application, the 43 homeowners who will suffer severely if this tower goes up, I respectfully request their appeal be granted and the CUP denied. I thank you for the time.
Yes.
And if you have any questions, I'd be happy to answer.
Any questions, John?
Chairman, just a cleanup item on the question you asked earlier. I wanted to make sure that we provided you with the site about the FHA requirement that doesn't allow a loan, and that is in a fall area. That's on page 7 of the appeal. Footnote 4 talks about the FHA regulation under hazards and nuisances and not being able to acquire financing if you're in a fall zone. I just wanted to make that as a matter of cleanup.
Thank you. Okay. You have any questions?
The only thing I'd ask is that, you think that includes the VA too?
I think you want to direct that to Mr. Campanelli.
Would that also include the Veterans Administration?
Yes, my understanding. Yes, my understanding is if someone's home is in the fall zone of a tower, no applicant can obtain a mortgage for any federally guaranteed loan. I have had situations where someone bought a house, a cell tower was built after the fact, they went to buy it, they went to contract, the buyer went for a mortgage, and their mortgage was declined specifically because they wanted an FHA guaranteed loan. And the mortgage company came back and said, you're in the fall zone of a tower. Federal law precludes us from granting a mortgage.
Thank you.
Anything else, gentlemen?
Nope.
Okay. Thank you, sir.
Thank you.
Is it you, Jeff? Okay, we'll move on then. If there's no comments or questions. Appeal number 2, rebuttal. This is Jennifer Ferguson.
Thank you. And just thank you. You went over the bald eagle stuff, so I won't need to do that. I actually have actually paid for coverage map where I did include what data they needed to use. This is not for an actual cell antenna, because when I asked for that information, I was not given the actual information to put it into the system to get that correct coverage. So this would be for Robie Creek's voluntary fire department radio system. This is for generic radio. This is the Morris Creek area. This is the fire department. This is the fire department. This is Brian Adams' location, and you can see where the little guy, but whatever that thing is called, symbol. That's the locations. This would be at the water tower, which is above the above this. This is where the fire department is. So this is the coverage that they would get, radio coverage, and this is the radio coverage they would get. And you can see the substantial difference. So it proves that Brian's location and the water tower location are much better for service for radio. So if it's better for service for radio, why wouldn't it be better service for cell tower? And that's from, hopefully I explained that okay. I don't know.
Where did you get these?
I had them done. I paid for them through tower coverage. It's a probably a company that a lot of these places use.
What's it called?
Tower coverage.
Oh, that makes sense.
Yeah. I had to actually get a subscription with them, and now I'll cancel my monthly subscription in a couple. So that's basically all I wanted to say about that. Other than him saying that there's.
Ms. Ferguson, can you show that around?
Oh, okay, yes.
Please.
I go this way. It won't fit over there.
You can pass it around.
Okay.
Yeah, to the just so the camera
There
gets
you
all
go.
of us.
Yes.
So I see.
Yes.
Okay.
except for Brian's location. I had did that one at a later date. So that one's fine too. Okay, okay, thank you. And then the other thing I wanted to just address real quickly was him saying that it's his chart that he gave you on them not being dangerous jobs, the cell tower workers, because what he failed to find out or tell you is that tower climbers are not categorized as an actual job. They're not called tower climbers. They haven't put them into a category yet. So that's why they're not on census as tower climbers, but they are under construction laborers and maintenance and general technicians. So they fall within what is considered one of the most dangerous. So just wanted to make a note of that. And you can verify that by, they have a show on PBS called From Frontline, which is called Deadly Cell Tower Climbers. And it's pretty much a documentary on the facts proving that it is one of the most dangerous jobs in America. Other than that, I think I'm going to wrap it up and say thank you. And I appreciate your time and all that good stuff. Thank you.
Okay, so wrapping up, I think we probably need to go into executive and have a conversation about procedure and how we move forward. Is that all right or no?
Yeah, you can move into executive session if you want to discuss potential litigation or exempt records. I think both of those would be applicable here. In order to go into executive session, you need to make a motion and then do a roll call vote.
Okay. You have a,
You know the numbers.
yeah, no, the code,
Oh,
206. How about Marion?
It's Idaho Code 34-206, 1D exempt records, and 1F pending litigation.
Can I do that at the same time? Okay. Thank you, everybody, for coming. We're going to move, I'm going to make a motion to go into executive session under Idaho Code 74-206-1D and 1F, pending exempt records and pending litigation.
second.
All in favor?
Aye.
Motion carries.
We need a
What?
roll call vote on that.
Do we? Okay.
Go into executive session.
All in favor?
Commissioner Sturm, aye.
Twilliger, aye.
Commissioner Holmes, aye.
There we go. Okay.
That means then you'll have to leave while we
Ready when you are. Hourglass.
Yeah.
Okay, coming back from break. What, 3:15-ish or 14. So at this time, we're going to close public testimony, correct?
Yes, if you would like to at this point.
At this point, I believe we will close, officially close the public testimony. And I'm not ready to make a decision. And the board has decided that, well, we can talk about it, but I personally don't have there's so much information to digest here that I'm not ready to decide. So I'd like to take a moment to review the record, take some time and a future date, deliberate, and then make a decision.
Yeah.
You guys okay with that, or would you?
No, I mean, there's quite a few
I'm okay
pages.
with how much time we looking at.
Yeah,
I don't, I mean,
A week, 2 weeks?
I need just a few days, if not, maybe a week. If that's
so,
okay with everybody.
Or next
Well, we
week,
have-
Thursday.
well, we have our regular meeting next Thursday anyways. So depending on how long that meeting is, we could do it after that meeting
We have another public hearing that day
on Thursday.
on Thursday.
What is it?
What is that?
The partial withdrawal property. Yeah.
Okay.
I mean, is that a long, expected to be long?
You never know how many people will show up.
Well, yeah, I know, but
Yeah.
I would recommend going a different date from that.
going a different day than that
And
one.
then if I make the 17th, it's for connecting zoning commission hearing, I can get ready for it.
So do it on that date?
Yeah.
Okay, wow. Well, we can do a special meeting, but that, I mean, I'm the one that doesn't have to drive, so that's kind of up to you guys. We'll pick a date.
So we have our meeting next week on the 10th.
And then the
So we'll
17th.
have our regular meeting on Tuesday, the 15th as
15th.
well.
I don't think it's, I mean, hopefully we'll be prepared by then, but I'm okay doing it then if you guys are.
Tuesday, the 15th is basically a week and a half. Does
You okay with that, Holmes?
you guys work with that? I'm fine with that. That's
Okay. So that'll be, well, after,
after our regular meeting. So probably,
it'll be a separate meeting, is that right?
you can do it prior to meeting, but we do need to set a specific time.
yeah, it has to be, so it'd be 1:15, your best bet, because we have the mornings
Well,
covered already.
As long as the agenda doesn't get too fat. I
Just
guess
keep
we
the
can push it
agenda
to
real
something.
short.
Yeah.
okay?
Well, that's the thing, is we have control over the rest of the agenda,
Okay.
so 1:15 on Tuesday.
That works for me.
Tuesday, the
15th.
So on Tuesday, the 15th at 1:15,
Okay,
we all good with
we'll
that?
see y'all again.
Mr. Chairman, I would,
Yes,
I would recommend just checking with some of the council in the room.
sure.
Make sure that works.
That work for you? Okay,
Sir?
you good? Okay.
Can I ask a quick question? Is that won't be public hearing though? That'll just be.
It'll just
Will
be
be.
our deliberation and decision.
Okay.
Go.
Planning on having an island for those people who can't make it for that.
Are we having what? Plan on having what?
An island to watch for those people who are here, since this was.
I mean, we-
Yeah, I think we can do that. We will make every attempt. We're kind of in the process of
We're in the process.
updating this room so we don't have these
It'll be
conversations.
easy just to
Yeah.
have it for viewing.
Yeah,
Not-
right.
Yeah,
We won't have to deal with the feedback issues
No.
that we're having with people
Right.
speaking, because there won't be anybody
Yeah.
speaking.
yeah, fair warning, it will be view only because we cannot take any more. We've closed the public hearing
Yeah.
portion.
So incidentally, on that note, please do not send anything to us because we don't want
Yeah.
the appearance of taking more information after this. And if you do, I want to open the email anyway. So
Yeah.
in this case, at least.
That goes for me as well, and
And
all of us.
And if I can additionally comment, being a public hearing and a quasi judicial hearing, you are subject to the open meetings law, which
Right.
means you as commissioners can't talk with each other about this until the continuing
Right.
hearing. And really, you shouldn't be formulating any opinions. All of your decisions should be made in front of the public at the next meeting and be deliberated on between each other at that point. So no conversation between each other or the public.
Correct.
Okay, what else do we need to cover? Yelena, we done until then? Okay, then we will,
For the new date. So, I mean, motion never hurt. I don't know if it's required, but.
What?
make a motion to have the meeting or,
Motion to table.
oh, okay,
Table the decision until.
okay, you want to motion it up?
Sure, I'll make a motion to table the deliberation until a future date of February 15th or March 15th at 1:15 PM. So we will deliberate and just make a decision.
Second.
Motion and seconded?
Just to clarify, that's also at this location.
Yes,
Right,
at this location.
All right, all in favor?
Aye.
Aye, motion carries. Okay, we will adjourn until 1:15, Tuesday, March 15th. Thanks, everybody, for being here. We do appreciate your participation and your time.
Don't forget. Good job, boys. Don't forget to take your evidence.
Oh, no, take more.
Give you some light bedtime.
Water bottle.
Give you some light bedtime reading. Yes, sir. How are you? Thank you, gentlemen.